Kako. Aloha, my Kako, and good morning. This is the September 8th, 2021 Land Use Commission meeting, which is being held using interactive conference technology, linking video conference participants and other interested individuals of the public via the Zoom internet conferencing platform in order to comply with ongoing state and county official operational directives during the still ongoing COVID-19 pandemic. Members of the public are able to view this meeting via the Zoom webinar platform. Whether you've been with us many times or this is your first time, I would like to urge all meeting participants the importance of, if you are speaking, to speak slowly, clearly, and directly into your microphone. Before speaking, it is extremely helpful if you state your name and identify yourself for the record. Also, please be aware that all meeting participants that this meeting is being recorded on a digital record. Your continued participation is your implied consent to be part of the record of this event. If you do not wish to be part of the public record, you should leave the meeting now. This technology allows the parties and each participating commissioner individual remote access to the meeting via our own individual digital devices. Because of that, and often due to matters entirely outside of our control, occasional disruptions to connectivity may occur for one or more members of the meeting at any given time. If such disruptions occur, please let us know, and please be patient as we try to restore audiovisual signals to conduct business effectively during the pandemic. For members of the public who may wish to testify during any portion of this meeting where public testimony is allowed, and who are accessing this via software, use the raise your hand function when you're an audience member. I will then call in, or whoever's chairing the meeting will call in audience members, admit them in to be a panelist, and then we'll swear you in, take your testimony. You will stay to answer questions from any of the parties and the commissioners, and then be moved back to being a panelist. If you are accessing this meeting by phone, you can raise your hand using *9, the key combination *9, as well as to request to be unmuted *6. Right now, there's no public testimony, so those who have your hand raised, you can lower your hands using the same lower your hand signal. From time to time over the course of the meeting, we will be taking breaks. My name is Jonathan Likeke Scheuer. I currently have the pleasure and honor of serving as the Land Use Commission Chair. Along with me, Commissioner Edmund Axon, Don Chang, Gary Okuda, our LUC Executive Officer, Daniel Oradenker, our Chief Planner, Scott Derrickson, our Chief Clerk, Riley Hakoda, our Program Specialist, Natasha Quinones, our Deputy Attorney General, Julie China, are all on the island of Oahu. Commissioner Nancy Cabral is on Hawaii Island. Commissioner Dan Giovanni is on Kauai. And Commissioner Leo Higashi is on Maui. We currently have 8 seated commissioners of a possible 9. Court reporting transcriptions at this time are being done from the Zoom recording itself. I note in regards to attendance, Commissioner Arnold Wong is excused for today's meeting, and Commissioner Dan Giovanni will leave the meeting shortly between 11 a.m. and 11:30 a.m. With all of that said, our first order of business is the adoption of the August 25th, 2021 minutes. Riley or Natasha, has there been any written testimony submitted on this matter?
Chair, this is Riley. No testimony on the minutes.
Okay, if there's any members of the public who wish to testify on adoption of the minutes, just adoption of the minutes from the August 25th meeting, please raise your hand. Seeing none, are there any comments or corrections, or is there a motion to approve? Commissioner Cabral?
My one good deed always, I'll make a motion to approve the minutes as presented.
Is there a second?
August 25th. Thank you.
I will second the motion, Dan Giovanni.
Thank you, Commissioner Giovanni. Motion's made by Commissioner Cabral and seconded by Commissioner Giovanni. Any discussion? Seeing none, Mr. Oradenker, will you please poll the commission?
Thank you, Mr. Chair. The motion is to adopt the minutes. Commissioner Cabral,
Yes, yes,
Commissioner Giovanni,
Aye.
Commissioner Axon,
Yes.
Commissioner Chang,
Aye.
Commissioner Okuda,
Yes.
Commissioner Ohikashi.
Yes.
Commissioner Wong is excused. Chair Schroeder.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Thank you very much. With that, our next order of business is Mr. Orodenker to go over our tentative meeting schedule.
Thank you, Mr. Chair. Tomorrow, we will be hearing the Maui solar matter and any remaining agenda or any remaining argument on Kihei High School, which is also scheduled for today. On September 22nd, we will be hearing DR 21-73, declaratory ruling request by Hono Ipu Hideaway LLC. And we will also be getting a status report on A87-610 KSB. On September 17th, I'm sorry, Mr. Chair, we will be having an additional meeting to adopt the Maui solar order as necessary. On September 23rd, we'll be hearing A15-798 Waikiki Properties. On October 13th and 14th, we have set aside time for the important agricultural land designation matter. That's pending a decision by the Attorney General on time for that meeting. Same for October 27th and 28th. On November 10th, we will be hearing A21-810 Akawa Solar. On November 24th, we will be adopting the order in that matter. On December 8th and 9th, we will be hearing A03-739 Woodward Airport Hotel on Maui. And that takes us through the end of the year.
Thank you very much. Commissioners, any questions for Mr. Orodenker? Seeing none? No questions? Okay. Our next agenda item is an action item regarding docket number DR 2172 Church, Hawaii, to consider the petitioner's petition for a declaratory order requesting clarification and correction to the LUC December 16th, 1992 boundary interpretation number 9248 and reimbursement of LUC and court reporter fees. I see Mr. Church is in the attendees. Can he be admitted, please? And is there anybody else who's to be admitted? Both, I don't know if both of the churches are at the same. Mr. Church, I can see you've been admitted. Could you enable your audio and video, please? Okay, I see that you're unmuted. Could you try your audio, Mr. Church?
Trying.
I can hear you a little bit. It's of poor quality.
Can you hear that?
It is distorted. Okay, I can see you now. Nice to see you. Can you try to say something?
We have a slow internet connection, so I hope it works. It worked before when we when we did something else with you, I believe.
Okay.
You connect to the audio.
I couldn't actually understand that last statement, so I'm gonna actually ask you to turn your video off to see if the audio quality improves by conserving bandwidth.
Okay, does that work better?
I can hear you. Oh boy, they left. They seem to have closed their connection. Mr. Derrickson.
Yeah, I'm here. Until they try to recontact us, I'm not quite sure what we can do.
And can we have their phone number? Can we at least call them? And
Yeah, Riley's trying to contact them right now.
thank you. Thanks for everyone for your patience. May I ask, do we expect Hawaii County Planning to attend?
No, we don't expect Hawaii County to attend.
Okay. So the
for
parties,
church
the
matter.
parties will just be the churches then,
Correct.
and OP presumably, or
That's correct.
okay. I see Mr. Church coming on.
Can you hear me now?
I can hear you now. That
Okay.
is actually much, much better.
I reconnected from scratch to take me out of video. I turned it off, but that didn't make any difference.
Got it. We can hear you now. And can we do an audio check with your wife as well, please?
Joni? She'll be back in a minute.
Okay.
She's trying to get the phone to connect just in case.
Okay. We realize that our
She's 20 steps away.
okay.
Okay, here she is. Say something.
Good morning.
Good morning. Great. Okay, we've established audio contact. That's better. So would you please identify yourselves for the record?
My name is Ken Church. I'm the petitioner. I live at Big Island. Yeah, 14 miles north of Hilo.
Okay, and your wife is the co-petitioner,
Yes.
and she is with you as well. And can you state your full name for the record?
Joan E. Hildahl. Joan Evelyn Hildahl.
Thank you very much. Okay, Office of Planning. Your Ms. Kato.
Sorry.
Are you going to record an appearance on this or no? I know you've.
Oh,
Wow.
I'm sorry. Alison Kato, Deputy Attorney General for the Office of Planning and Sustainable Development. Also here are Rodney Funakoshi, Lorraine Maki. I also see Aaron Setogawa and Mary Alice Evans from the Office of Planning and Sustainable Development as well.
Thank you.
Thank you.
Okay. And the County of Hawaii is not appearing. Before we proceed further, let me update the record. On June 17th, 2021, the commission received the petitioner's filing and the cashier's check for $1,000. On September 1st, 2021, the commission mailed and emailed the meeting agenda for the September 8th and 9th, 2021 meetings to the parties in this docket and to the statewide and county lists. Also on that day, the Office of Planning and Sustainable Development filed its position statement. This is exhibits 1 through 4 and a certificate of service. The commission also received an email from Deputy Corporation Counsel Jean K. Campbell stating they were taking no position on the petition. Now for the parties, including Mr. Church, I'll go over our proceedings for today. First, I will give the opportunity for you to comment on the commission's policy governing reimbursement of hearing expenses. I next will recognize the written public testimony that has been submitted in this matter, if any. I will then call for anybody in the audience wishing to give public testimony using the raise hand function. Following any public testimony in this matter, I will call for the petitioner, or I will call for the petitioner to make their presentation. Following the petitioner's presentation, we will hear comments from the Office of Planning and Sustainable Development, and then we will have questions for both following their presentations for both Mr. Church and the Office of Planning. If there's time available, I may ask commissioners to ask for further testimony from the state or other parties based on the discussions to that point. Based on the information received today, the commission can determine further action. Are there any questions for our procedures for today, beginning with Mr. Church, yes or no?
As I understand what you said, you're going to first deal with the, I guess, my supporting arguments regarding the reimbursement of fees. Is that what you?
No. So, and I might ask for some clarification from our or assistance from our staff in explaining this. You've had a special. You have part of your motion in front of us, I understand, is for the reimbursement of the filing fees that you've filed to date on this petition, as well as in regards to your still pending petition for a district boundary amendment. Do I understand correctly? That is what your request for reimbursement entails?
That's correct. And
okay.
You mentioned court reporter fees, but apparently that's no longer applicable.
Well, so just hold on. So in addition to those filing fees, there's hearing expenses fees, and it is in our administrative rules that for the cost of the hearing, a petitioner covers a portion of those fees. Mr. Ordenker, can I ask you to explain what that is and how this may relate to one of the pending motions of the petitioner?
Thank you, Mr. Chair. The expenses related to hearings are usually limited to fees associated with court reporter. And as in the past, we've had a physical court reporter present. Currently, we have it being done remotely, but the expenses still exist. The parties is required to pay a pro rata share of those expenses for each hearing where there is more than one petition or matter being heard by the commission. If there's no other matter being heard by the commission, then the petitioner or move on is required to pay for the court reporter fees in their entirety. At this current time, we don't have any further expenses. Under normal circumstances, there may be expenses associated with a venue or such, but in this case, since we're appearing by Zoom, we don't have those expenses.
So, normally, Mr. Church, this portion occurs in every docket, regardless of, so we're not taking up at the very first your request for reimbursement of your filing expenses. We're only taking up this standard procedure, which starts at the beginning of every single hearing, which asks a petitioner whether or not they're going to comply with the pro rata or share of hearing expenses, which have been reduced but not eliminated entirely by our going to a virtual format and having a transcription done via Zoom. So do you understand that first matter now, Mr.
I
Church?
believe so. Do I get a copy of that for the payment of the fees?
You would be billed for the payment of the fees.
Okay,
Okay, so anyway, but right now we're not even discussing that. We're just discussing our procedures. So we're just going over that procedure. Then we'll go into public testimony. Then we'll go into your presentation and presentation from the state. That's our procedure for today. After that, we'll ask questions of the state, you after you present, the state after the state presents. We might ask more questions of you or other parties, and then we'll deliberate. That's our procedures for today. Do you understand our procedures for today, Mr. Church?
I believe so. Am I allowed to ask the state OP questions relating to whatever they have to say?
Let me ask Mr. Ordenker or Ms. China, but I believe as a party, that would be allowed.
Actually, Mr. Chair, that's not quite correct. This is not an evidentiary hearing. There is no opportunity for cross-examination as there are no witnesses. The petitioner or Mr. Church can make statements to controvert the OP's position, but since this is a declaratory ruling,
Right.
you're really not, it's not proper to cross-examine counsel.
Yeah, so Mr. Church,
Understood.
you understood? Okay, great. So do you understand our procedures for today?
I believe I do, yes.
Okay, a yes or no would be great.
Yes.
Thank you. Ms. Kato, any questions on our procedures?
No questions, thank you.
Right, okay. Mr. Church, I will now ask you about your agreement with the reimbursement of hearing expenses, as we've discussed earlier. HAR, Hawaii Administrative Rules 15-15-45.1 discusses the reimbursement of hearing expenses. Can you tell me whether or not you've reviewed that and whether you plan to comply with that policy?
I have reviewed and I will comply.
Thank you very much. Mr. Hakoda, now we'll move to public testimony. Mr. Hakoda or Ms. Quinones, has there been any written testimony submitted on this matter?
Mr. Chair, this is Riley. No public testimony on the church matter has been received.
Okay. I will now ask any members of the audience. So the churches will get to present themselves. Ms. Hildahl and Mr. Church will get to present themselves as petitioners. Are there any members of the audience who wish to testify on this matter today? If so, use the raise your hand function. I don't see anybody who is calling in. So just use the software raise your hand function if you wish to testify on this matter. Going once, going twice. Seeing none. There's no public testimony on this matter, and I'm going to close public testimony on this matter. With that said, we can now move to your presentation, Mr. Church.
So I have prepared a short statement, probably take 5 minutes thereabouts.
Okay.
My wife Joni is also asked to give her own statement following my remarks, and we will
Yes.
very much appreciate your patience. We thank everyone at the LUC and the state and county offices of planning for their patience and for encouraging us to this point of appearing before you. We also thank our neighbors and friends that have encouraged us also. We recognize and sincerely appreciate the substantial service to the community that the volunteer commissioners patiently provide. My wife Joni and I purchased the property in 2014, lay along the Hamakua coast and comprised a former sugarcane field. We intended to build our home there and develop the property for agricultural uses. After the DLNR strongly advised that we hire a professional to develop and submit our applications, we contacted 5 firms that provide such a service. They all told us to expect the process to be very expensive and that it would take a lot of time with an uncertain outcome. In the end, they all turned us down. They generally said that successful permitting by the DLNR had become so difficult that they were no longer taking on new clients in this regard. Therefore, we undertook to submit our own applications. This has also been to the frustration of the commission staff, who regularly reminded us throughout this process to hire a professional. Going the professional route is simply too expensive a process for us to use. In 2018, we
Mr. Church,
Yes?
1 second. I'm perceiving that you might be varying your distance to the microphone. It's fading a little bit. We got everything
Okay.
you said, but try to be consistent, please.
Okay,
Thank you very much. Sorry to interrupt you.
that's fine. In 2018, we determined to file a petition with this commission to rezone our property into the ag district.
We cannot hear you.
In 2018,
Better.
we determined to file a petition with this commission to rezone our property into the ag district because its zoning simply seemed wrong. And we remained in fear of the DLNR. We were also concerned that our investments in our property were diminished by its apparent conservation zoning. While waiting for over 3 years now for our petition to be heard, it became increasingly clear to us that our property was never rezoned into the conservation district. Regarding our subsequent petition to the commission today, we had to do an inordinate amount of sleuthing to find LUC evidentiary records, which were not easily available through channels administered by the LUC's office and its website. This resulted in further delays and the repeat of expensive filing fees. Our petition today references the LUC's record of its 5-year boundary review in 1969. It is found in a book, which I will refer to as the report. Report not only documented its recommendations to the commission, but it also served as the commission's official record of its action when rezoning land. At a cursory read level, it is easy to become confused and misapply the report's recommendations versus actions that the commission approved. The OP's statement of position to this petition also describes that it also has found the report to be confusing. While we very much appreciate that the State Office of Planning issued a statement of position that supports our petition, we disagree that its analysis of the report is so narrowly focused to the unique characteristics of our property. If the commission agrees to such a narrow focus, it will result that other similar coastal property owners will continue to be improperly impacted. This will result in repeated, needless wasting of scarce government resources, the waste of the commissioner's volunteer time, and an unnecessary and burdensome continuing cost and inconvenience to property owners. Our petition references the commission's DR 9921, which is for very similar land towers. Like our land, it also lays along the Hamakua coast. In that case, the commission corrected all of map Beach 59, which comprised about 20% of the area from East Kohala to Hilo. We believe that the commission should have corrected the 5 maps to cover this coastal area over 20 years ago. We believe that the remaining 4 maps should be corrected by the commission now to reflect the report's description of the commission's 1969 approved rezoning of coastal land. In DR 9921, the commission quoted the report's record of the commission's 1969 rezoning action in its stated applicable legal authority sections, items 1 and 2. These two sections referred to the coastal area that is shown on all 5 of the maps. Unfortunately, the commission's resulting order only required that map H59 be changed, even though the quoted reference from the report describes the 5 coastal map areas. The report is not an easily found record of the commission. Recently, we first uncovered a reference to it in an old Office of Planning document, or we would never have known it existed. Then, after an exhaustive search online for the report, instead, we found a reference to the commission's DR 9921. These were the first clues that caused us to believe that our property may have never been rezoned. Even then, we could not find DR 9921 in the LUC's records other than a reference to its docket number on map H59, and the report was even harder to find. Since we made the LUC's administrative office aware of that error in June, that order now appears in the LUC's online files. The report describes that it never intended that its recommended maps were to be the only reference for district boundaries as the official record. It seems to us, when combined, DR 9921 and the report points that the LUC's administrative office, State Office of Planning, and even the County of Hawaii were aware or should have been aware that the LUC's official district maps could not be relied upon in the way they have been in determining coastal district boundaries since 1999. We cannot understand why these two records were so hard to first identify, that they even existed, and then were so equally hard to find. This petition is about errors which we feel have been made by the LUC. That is why our petition has also requested the refund of filing fees. We respectfully ask that the commissioners grant our petition. We hope that this brief introduction explains why we are appearing before the commission today, and we look forward to our exchange of information with the commissioners with enthusiasm. And I guess now my wife will make her presentation. Hers is shorter.
That would be great.
In our search for a place
It is hard to hear you, Ms. Hildahl.
Okay, I'll get closer. In our search for a place to retire, Big Island won out overall, and we're so very happy to be here. We were warned about buying conservation property. So before we bought, we researched the law and felt confident that the law here not only supported, but encouraged self-sufficient ag. And what we wanted to do was live here and simply grow food. Little did we know how hard that was to be. Ken has been struggling through all the legal channels we are aware of since buying the property in 2014. They told us to get a pro. We tried, but all the planners and lawyers we contacted. Hello? Can you still hear me?
Still hear you.
Okay. We tried, but all the planners and lawyers we contacted didn't want to take us on, mostly after speaking with OCCL. Couldn't understand, but anyhow, it was really curious, and it was the reason Ken took this all on himself. After 4 years of dealing with OCCL, gratefully, with some successes, but they didn't want to give us the right to use for ag use without endless approvals and constant threat of fines. After a couple of years of this, we began to feel like we were fighting for more than just us, as how many folks here who've inherited or however attained properties have the freedom, funds, and times to go through this. How many have just given up their dream when they were simply wanting to grow food, have a few cows, horses, or simply put up a fence without the threat of fines? How many don't have the thousands, 5,000s, or the time it would take? How many uses are then just unpermitted? In the meantime, sadly, how many conservation properties are overrun with fire ants, invasives, pigs, etc., when the owners could have been simply caring for them? It's not that we are opposed to regulations. We are not. We love our Aina and respect and appreciate the efforts to protect it and feel our government here does too. It wasn't until just this year, after 7 years of struggle, that Ken finally discovered the actual 1969 report that documented the commission's process and actions to establish conservation district boundaries. Here's some of what it said. In cases where the shoreline is bounded by steep cliffs or a poly, the top of the ridge was supposed to be used. And the steep poly coast of East Kohala, extending all the way to the polylands of the Hamakua coast, shall be conservation with the ridge top as the boundary line. And one more thing, ag land was supposed to be excluded from the conservation district. The undefined lines, incorrect in some cases on the maps, were never meant to be used solely for determining zoning. Unlucky for us, none of the planners, lawyers, or agencies had ever volunteered or suggested researching these documents. Anyhow, at this point, we humbly ask that you try to understand our frustration overall, and now please grant our petition and ultimately the freedom for us to finally use our property for agricultural use, grow food freely without endless permitting and the constant fear of fines. Thank you for listening.
Thank you very much, Ms. Hildahl. I'm going to note for the record that at 9:37, a minute ago, we were joined by Commissioner Wong. Quick audio check, Commissioner Wong.
I am here.
Okay. Okay. So if I understand correctly, Mr. Church, you don't have anything further at this time, but you're available right now to answer questions from the commission?
That's correct.
Okay. Commissioners, are there any questions for Mr. Church at this time? Commissioner Cabral.
Yes, thank you, Chair. I guess this could be either Mr. or Mrs. Church. I've been confused over some of the statements. So, but yet what you've just stated clarified that. I want clarification. So when you purchased the property, I think that was in 2014 or so, from Jim McCauley, you were aware that a part of the land, because you have several parcels, but one portion of the land was in conservation. You were aware of that at that time, and you were aware, or were you aware that there was restrictions on what that usage would allow?
We were aware that it appeared to be in conservation, and in fact, that's what we believed it to be. And for clarification, when we first bought the land, McCauley required that all 3 of the oceanside lots be purchased as a single purchase. And we really didn't have enough money to do, well, we had enough to do it, but it would cramp our ability to build. So we agreed to buy them all. And then we first went through a process. Well, I'll go back a little. There was a railroad crossing the property, or a former one, and that comprised 3 lots, and then there were 3 oceanside lots. So we applied to the DLNR to combine and then re-subdivide and eliminate the railroad lots. Then once that was done, we sold what I refer to as the south lot to another party who I believe is even in the audience today. Does that answer your question?
Yes, somewhat. So when you reference the fact that you purchased this land with the dream of building your home on the property and raising vegetables or fruits for your self-use, you are referring then to the idea that you were going to build your house on that conservation land or on the other parcels, or was that just part of the unknown dream of just building your land on that oceanfront area? I want to get clarification as to your expectations and your knowledge at the time of purchase.
Okay, all three of the TMK lots, which comprise 2 legal lots of record each, were shown on a map to be in the conservation district, and that's what we understood them to be, all 3 lots. And my wife wants to add something. Just hang on.
Yes, we were aware that it appeared that it was conservation land because of Mr. Macaulay's boundary interpretation of 1992. But we also researched the laws, and everything that we understood stated that we could do agricultural use. We could use the land for agricultural use. So that's what we do right away.
Okay, so you're saying that you thought you could use agriculture use, but then after you got it, you're saying DLNR restricted you and you were not allowed to have agricultural use on the conservation land?
We were allowed to have agricultural use. We permitted every single little thing. For example, when we first applied for 13 fruit trees, it took an inordinate amount of time because we were in New Zealand at the time, and they insisted on us using the mail. And then they held out, and they finally asked, "What are you going to do with each shovel full of dirt that you are going to plant with the dirt that you take out for each hole when you plant these small trees?" So anyway, and it's been an uphill climb about the agricultural use ever since.
Okay, my next question is, and this is somewhat just in general in real estate. Typically, when I have been involved with sales, do you think that you purchased that property at a market, the value of your property was less because of the restrictions on the use of that? Or, I mean, that's typically what I see happen when you can't use land, it sells for a lesser price. And I'm not familiar with your purchase agreement with Mr. Macaulay, but was there any kind of discount? Did you think you got a discount on your purchase for those restrictions?
Actually, no, it's a little more complicated because the land had been used for sugarcane from the 1850s on. And when Macaulay purchased it, the last crop had just been harvested. That was in '92. We read the DLNR's rules, and unlike your rules or the State Office of Planning rules, the non-conforming use of land can be resumed at any time. Your rules for conservation land, the rules are that it can be resumed at any time in the future. And it took a long time for us to sort that out with the DLNR. And even then, they would never formally tell us that we could do it. They gave vague answers, and it just went on and on and on in ad nauseam. We're talking about years of exchanged letters and information.
Okay, well, thank you very much for the continued information. Thank you.
Commissioners, further questions for the churches at this time, our church in Hildal at this time? Commissioner Okuda?
Thank you very much, Mr. Chair, and thank you very much for the petitioners for making their presentation. Let me just ask some preliminary questions. Mr. Church, Ms. Hildal, you understand that the Land Use Commission is a quasi-judicial body, meaning we have to follow the law whether or not we like the law. Do you understand that?
Yes,
And you understand that because the Land Use Commission is a quasi judicial body, we're not like the county council or the state legislature where we can make decisions and unilaterally change the law just because we want to see a certain outcome. Do you understand that?
yes,
You mentioned you had difficulty getting professionals such as attorneys to represent you in this matter. But do you understand that whether a party or person or entity is represented by an attorney or not represented by the attorney, the Land Use Commission must apply the law without favoritism or without fear, irrespective of whether or not a party has an attorney or doesn't have an attorney. Do you understand that?
yes,
Do you understand that because of that, and I don't mean to be rude in any of my subsequent questions, but if you continue without an attorney, you will be subject to the same standards that we would apply to an attorney. Do you understand that?
yes,
And are either of you an attorney?
no,
So you understand that if you proceed without an attorney or the advice of any type of professional, you may be putting yourself at risk moving forward. And the risk might include the fact you might say something or do something which may negatively impact your request for relief or other things from the Land Use Commission or any other body. Do you understand that?
yes, and we humbly put ourselves before the commission. We're real people just like us.
Okay, and I assure you, myself and other members on the commission and including the staff, we neither favor or disfavor anyone because they have or they don't have an attorney or because who they are or who they are not. We really try to just look at the law that we are have taken an oath to apply. So I assure you that. Let me ask you this. I'm going to ask some questions which may or may not be related to statements you've made here, which seem to be consistent with your boundary amendment filing, which is docket number A18-805. If you object to any of my questions, tell me you object and we can deal with it at that point in time, because it's not my intention to sandbag you, set you up or anything like that. I'm asking these questions because we need a full record before we make a decision. Do you understand that?
Now, the petition you referenced is the first petition we filed, not the one that's before you today.
That's correct. But let me ask these questions and you can stop me.
Let me, if I may, Commissioner Okuda.
Yes.
Do you have a sense of how long your questioning of for Mr. Church and Ms. Hildahl might be right now? We're running up into having gone on 50 minutes, and I just want to be aware of the need to take breaks and have you have an uninterrupted.
Yes, thank you.
session.
I believe 10 minutes, but this would be an appropriate time to take a break if you wanted to.
Okay, it's 9:50 a.m. Let's take a break, a 10-minute recess until 10 a.m. and we will continue with the questioning by Commissioner Okuda for Mr. Church and Ms. Hildahl. We're in recess for the next 10 minutes. It's 10
Okay.
a.m.
Yeah. Now
We're
real
back in-
busy.
We're back in session. Before Commissioner Okuda continues with his questioning, Commissioner Wong, you had something to raise?
Yes, Chair. I just wanted to say, I read the written testimony of the churches, and I came in when Mrs. Church or Hilda, she came on board to do her testimony. So I just wanted to say that on the record.
So you're familiar with all of the proceedings in this to the present moment?
Yes, Chair.
Thank you.
Thank you.
Okay, Commissioner Okuda.
Thank you very much, Mr. Chair. And either of the petitioners at any time can answer this question. Okay. So going back to my line of questioning, I heard and listened very carefully and took to heart the statements about from you, Mr. Church, and Ms. Hillel, rather, as far as having to deal with the government agencies and your frustration. But do you understand that the Hawaii Constitution places certain important obligations to protect conservation land and agricultural land?
Yes, I think today's petition is not about whether this is conservation land or not. It's about whether it was put in conservation in 1969. And that's where we want to go in this report. The report is your own record. That's what it says. And I can read you,
no, you don't. Yeah, pardon me if I can interrupt. Let me tell you why I'm asking these questions. I am asking these questions to determine whether or not what you have presented at this point in time, okay, just at this point in time, whether you satisfy the burdens set forth by HRS section 91-1, parent 5, close parent, which basically provides that and let me quote this, quote, except as otherwise provided by law, the party initiating the proceeding shall have the burden of proof, including the burden of producing evidence as well as the burden of persuasion. The degree or quantum of proof shall be a preponderance of the evidence. So the question I'm asking, and these series of questions are simply to determine whether or not you have met the initial burden before we can even consider the relief that you're asking for or the specific arguments that you are making. Okay, so that's the reason why I'm asking these questions. I'm well aware of what you're asking for. So my initial question is here, and this is with respect to your complaints or your commentary about your interactions with the government agencies that you described. You are aware that the Constitution specifically mandates certain protections that have to be given to Hawaii's resources. Do you understand that?
Yes.
Okay, and just so that we're clear, I'm talking, for example, about Article 11, Section 1 of the Constitution, which states, and I quote, "For the benefit of present and future generations, the state and its political subdivisions shall conserve and protect Hawaii's natural beauty and all natural resources, including land, water, air, minerals, and energy sources, and shall promote the development and utilization of these resources in a manner consistent with their conservation and in furtherance of the self-sufficiency of the state." You understand that we as a government agency, even though we might be volunteers, we are bound to carry out that admonition or command of the Hawaii Constitution. You understand that?
Yes.
Okay. Now, I'm asking these questions now to determine whether or not we have a sufficient basis to give you a relief on your declaratory relief petition. And I'm specifically looking at Administrative Rules Section 15-15-100 to determine whether or not there's a basis here, or whether or not this petition should be denied, or whether or not perhaps the petition should be continued or scheduled for a hearing and possibly consolidated with your other petition. Okay, and one of the things I'm looking at is to determine whether or not we actually have a non-speculative question here, or whether we're basically dealing with something speculative or does not involve an existing situation. Okay, you stated that you intend to have agricultural use. Is that correct?
Yes.
Okay. When I looked, well, what in the record that you have presented here indicates what type of agricultural use is intended?
We intend to grow agricultural crops for resale in the local farmers market and also for our own use.
Okay, but where is there a specific description, or is there a specific description of the crop or crops that you intend to grow? And the reason why I'm asking this question is when I look, for example, at the environmental assessment that had been filed in the related docket, there's just a description of the residence that you intend to build, and there's no discussion about the environmental impacts, if any, or the lack of environmental impacts occurring or arising from agricultural activity.
So,
in other words, let me tell you where I'm going with this and my concern, and maybe you can address it. This appears to be an attempt to place mainly a single family residence on agricultural land if you get the relief you're seeking from us, either through this interpretation or declaratory ruling or otherwise.
as I said before, we're using the DLNR, who administers their own rules, has already acknowledged vaguely, and it's, I believe, Exhibit 72 in that document that you're looking at. They said that they have allowed us to continue or resume the non-conforming agricultural use of the property, which was already defined, and he says it in either that letter, there's 3 or 4 letters in a row. Mr. Lemo came back and said, including the cultivation of the land right up to the top of the fall, as an allowed non-conforming use. In other words, I didn't need a permit for it. He acknowledged that, seemingly he acknowledged that I had that right. So that original petition said, we're doing this. It's already being done, so we aren't anticipating a change. We're doing ag on the land. However, because he wouldn't make it clear, he wouldn't, I mean, we can get into the textual language here in those letters if you want to examine that, but I didn't prepare myself today to talk about that, as I don't see it as relevant to the current petition. And that's my answer, I guess.
Okay, well, I'm only speaking for myself, and I only have one vote, and I don't necessarily contend that, you know, I'm never wrong. So I'm only speaking for myself as far as these questions. But you are aware, are you not, that very recently in a petition or cross petitions brought by the County of Hawaii and by a number of petitioners, including Rosehill, ROSEHILL, these were DR 20-6 69 and DR 20-70, the Land Use Commission reaffirmed the fact that if it's agriculturally designated land, only a lawful farm dwelling is allowed. Are you aware of that?
Yes, it's rather interesting. Mr. Lemo testified at McCully's hearing before, not these same commissioners, but before this commission. And he told them that Mr. McCully could build a farm dwelling that was an allowed use. So subsequently, when we came along, we applied to build a farm dwelling. And I think there was about 20 pounds of documents submitted in multiple copies. And the chair came back and said, there's no provision in the land use or in the conservation district for a farm dwelling. You should rewrite this entire thing and resubmit it and take the word farm dwelling out and put residence, single family residence in. So we did. So
Okay.
Mr. Lemo told you that we can have a farm dwelling, and the chair of the DLNR said we couldn't.
Okay, well, let me ask you whether you're aware that not only in the DR orders or matters that I just referenced, but in at least 2 prior land use commission rulings dating back several decades, it's been made clear, has it not, that a farm dwelling defined under HRS 205-4.5A4 is either a single family dwelling that either must be located on and used in connection with a farm, or where agricultural activity provides income for the family occupying the dwelling. In other words, residential use of a farm dwelling without any connection to agricultural use is not an allowable farm dwelling, and the agricultural use must provide income to either or from that actual parcel where the farm dwelling is located, or to the family occupying the farm dwelling from some other agricultural parcel. In other words, simply growing a papaya on a lot for one's personal consumption does not make the dwelling a farm dwelling. Do you understand that?
Yes.
In other words, even though we might know from common knowledge that people put residences, sometimes big houses, what you might even describe as a McMansion, on agricultural land, and there's no income producing crops taking place there, even though that might be taking place. The fact that something is taking place which violates the law doesn't make it right. Do you agree with that?
Yes. The problem here is, it seems to me we're going back and forth between DLNR rules and Land Use Commission rules. DLNR rules are different. And so everything we applied for was according to DLNR rules until we came with this petition and said, you know what? You never put it in the conservation district in the first place.
Okay, well, again, this goes to whether or not, and this is going to be my final couple questions, and it goes to whether or not you're meeting your burden of proof to show that we have something which is more than a speculative or theoretical question, which would allow the granting of a declaratory ruling. So my final set of questions, basically this, deal with the intent to have a farm dwelling which complies with the requirements of the law. Have you ever filed a Hawaii general excise tax return where you reported to the Hawaii taxing officials income from farming or agricultural production?
We have never filed I think we're coming back though. And I don't mean to say.
I'm sorry, Mr. Church, I can't
You're
hear
fading
you.
out, Mr. Church.
Okay. The current petition is not asking you to rezone. The current petition is to issue a declaratory order that it was never zoned in conservation in the first place.
Yeah,
So I
Mr.
recognize-
Church,
Yep.
Mr. Church, I'm sorry to interrupt. I'm again just trying to determine in my own mind, and by the way, I haven't made up my mind at all in any of this. I'm just trying to find out whether or not there is a sufficient controversy which meets the burden to allow a declaratory ruling. That's all. And so please don't read anything into my questions. And my question, I believe, are basically yes or no questions. So the question is, have you ever filed a Hawaii general tax return, a Hawaii GE tax return, where you reported income from agricultural or farm activity?
No, we haven't. This is Joni.
Okay.
And I wanted to answer your previous question also. At the point at which we put in our CDUA for our single family residence.
Sorry, one moment, Ms. Hildahl. Do you have the audio playing in the background? Are you watching this via another device?
No, that's not us.
Oh, somebody. Okay. Sorry, we're
That's
picking
not
up.
us.
Thank you. Mr. Sitagawa, can you mute?
I welcome you back. Beautiful afternoon at Village Kihei National Tennis Center.
Okay, it was Mr. Sitagawa. I just muted him. I apologize. Please continue with your response, Ms. Hildahl.
Okay. I wanted to answer, well, the first question was about the tax. And the reason that we hadn't was because we had no, our trees were small when we planted them, and there was no crop to sell or anything at that point. And also when we did apply for our farm dwelling first, and then our single family residence, we had already gotten permits for 13 orchard trees, which were also still very small, but we had every intention of selling them if we could at the point at which they had fruit on them.
We also had a crop of 300 pineapples growing. And in fact, they've been cultivated under now because it get 3 years of use of them and then you don't get good production. What happened here that confuses this is we could not get a straight up and down letter that was clear from conservation that we're allowed to do non-conforming use on the property. And because the DLNR had visited the property one time when we weren't here, they went all over it, and my neighbor said one of their representatives even had a gun. We began to think, why are these guys, are they out to get us? So the conservation rules that commercial use of conservation law or ground is strictly prohibited. And here we were commercially using it. So we stopped going to the farmer's market and we harvested our last pineapples and said, we better quit until this is sorted out.
Okay, my final question then is that if you intended actual agricultural uses, why wasn't there a detailed description of the potential environmental impacts, if any, of the intended agricultural uses presented in your environmental assessment?
Well, it sort of is there. We referenced our permit for a house and the EA for that. And it was all revealed in there that we had completely converted the property into an ag use property. Just as a sidebar, we have a large Kubota farm tractor with a rototiller. It's stored in our ag use storage and processing structure where there's a full washroom facility there. There's a sink and a countertop to process stuff. We were all set up to get going. And then in the end, they gave us the permit to build a house, but they would not clearly say whether we could do ag use. So, and we were wary of them because they find people all around us upwards of $15,000 for every single violation. So we stopped. And if we don't have a license today, that's why, the tax license.
Okay, thank you very much for your answers. They have been very helpful. Thank you, Mr. Chair. No further questions.
Thank you, Commissioner.
Can I make one further statement?
Ms. Hildall, you may respond, but you need to get a little closer to the mic.
Okay. It seems to me that the whole question here is, do you consider the 1969 report, which contained recommendations and actions taken by the LU for determining conservation boundaries, to be the law, or do you consider the map to be the law? I think that's really the crux of the case here. And also in our statutes, the Hawaii HAR and our statutes, it says the highest protection was to be given to ag land, which our property was intensively being used for ag land in 1969.
Your response is finished, Ms. Hildall.
Yes, thank you.
Anything further, Mr. Okuda?
To that, your own rules and the statute refer to the fact that the land has to have the capacity for production of agricultural crops. It does not say that it has to be used for that.
Anything further, Commissioner Okuda?
Mr. Chair, nothing further. Thank you very much.
Okay, thank you. Commissioner Chang, thank you for your patience.
Yep. Thank you very much. And thank you very much, Mr. Church and Ms. Hildall. Appreciate all the research that you've done. I just have a couple of clarifying questions I want to ask you so that I'm very clear on what the record is. In both your opening statements and your files, you referenced that DLNR recommend getting a professional. Was that for purposes of getting a conservation district use permit, or was that for getting a district boundary amendment?
It was for getting several ongoing CDUPs.
CDUPs, okay. So, it appears as if, and your own testimony today, was that when you bought the property, you knew that it was zoned conservation. Is that correct?
We knew that it appeared to be zoned conservation.
Well, it is the different, well, let me ask you this. You also filed a district boundary amendment. Is that correct? To change this from conservation to agriculture. Is that correct?
At that particular time, we believed it to be in conservation.
Okay. And prior to that, my understanding is that Mr. McCulley, who previously owned the property, also filed a district boundary amendment in 2005 and 2009.
Correct.
Were you aware of that? Okay, so
Correct.
you knew that.
Yep.
So, okay. So everyone, including yourself, when you purchased the property, when you filed your DBA, when the McCulleys also filed their DBAs, understood or believed that this property was conservation.
Correct.
Is that correct? Okay, very good, very good. So, and you went so far as to prepare a FONSI in your DBA, is that right?
Yeah, we provided an EA and then you made a FONSI. We provided a draft FONSI.
Okay, so I mean, Mr. Church and Ms. Hildahl, you actually spent a tremendous amount of time, it appears, working on that document, as well as all of these different actions that you found. So you've done, I mean, you both seem to be extremely bright people who have the ability to utilize these resources, and you presented your case before us. And I understand that the question that you have in this particular declaratory action is whether the Land Use Commission, based upon the information you provided, should now, and you believe that there was an error, should now change the zoning on this property from conservation to agriculture. Is that what I understand your action to be?
Sort of. My wife also wants to say something.
Okay, go ahead.
We're talking about whether you're implying in your question, it would seem that you believe that your district map is final. And I'm saying DR 9921 and the report itself describe that the maps are not the final authority.
Okay.
It's very well described in the report. And let me just, I want to read a sentence from that because we're going back and forth on my original petition. It's not unusual that someone files a petition and then new information comes available and they say, in this case, we say, well, it's not even in conservation because the official record of the report. And I want to just, with your permission, read the preface page of the report. It says, chapters 4 through 7 are a summary of the recommended changes to the district boundaries in the 4 counties. Now, with emphasis, since these were acted upon by the Land Use Commission, I'm adding that, during the preparation of this report, we are able to provide the commissioner's decisions with respect to them. In this way, the text becomes not just a report to the commissioners, but a record of its actions as well.
Okay. Thank you. I appreciate that, Mr. Church. I think that there are also other legal principles that guide us. Principles like reliance, like estoppel, which essentially means that for probably the last 50 or so years, is that correct? Maybe that long. Everyone has relied upon the information, the long line of information related to this property, that the property is zoned conservation. Even you relied upon that when you purchased the property, when you went to see DLNR, even the McCulleys. Everyone relied upon that information. In my view, you haven't provided us new information to reconsider this. You provided us a new interpretation of information that had previously been considered when the property was originally zoned. So I think that that's the difficulty I'm having, is that you relied upon certain documentation and information. The McCulleys relied upon certain documents and information. And as Commissioner Cabral said, the price may have been based upon that particular zoning being conservation. So I am troubled that I don't see new evidence. What I see is your interpretation of information that had been previously been the basis for the zoning in this property. So that's sort of my struggle with this current petition, or this current declaratory action that you're presenting to us, is that you're not providing us anything new for declaratory action, but you're asking us to reopen a matter that had previously been resolved, settled, and relied upon by all the owners. Do you understand some of the challenges that I'm having here?
Yes, I do. And Mr. Church also wants to answer this question, but I want to say that in 1992, Mr. Macaulay was given a boundary interpretation. It wasn't a final law. He was given a boundary interpretation, which is there's allowed to be appealed. Anyways,
okay.
Mr. Macaulay had uncertainty. Otherwise, he wouldn't have gone through the motions that he went through. And also, we've had uncertainty ever since, because we've gone through all these motions to try to understand what's really going on. And when we finally found the law written in black and white, clearly, to me, it seems that that may be new information pertaining to our property individually that shows that it should never have been put into conservation. If it had been, I don't think there is any documentation that says our property was put into conservation. If it had been put into conservation, where are the sporting documents?
In my view, the supporting documents are the zoning maps, all of the fact that several DBAs have been filed to change the zoning from conservation to agriculture. And I do appreciate that both of you recognize that there are different purposes for conservation lands. So I understand DLNR's questioning about, what type of agricultural uses were you proposing versus if it was agriculturally zoned lands. Yes, a farm dwelling versus a residence, there's distinctions. So you seem to be very akamai, or you understand that there is a difference between conservation and agricultural uses. But go ahead, Mr. Church. Did you want to answer or clarify?
Yeah, I want to answer one part of your question or respond to it. You referred to estoppel, and I don't know if I pronounced it right, but I think I understand what it means. In 1999, 30 years after these maps were drawn, and after boundary interpretations, 2 successive ones were issued to him, along comes Mr. Stengel in DR 9921. And just like us, he said, you know what? Uncertainty remains. This land was never put into conservation. And he made his case before an earlier commission. And in their conclusions of law, the commission made a statement under the applicable legal authorities there. And I could read it to you if it would be helpful, but I'll say, they said, no, those 2 boundary interpretations that were issued are incorrect. You have provided evidence in this report that says the top of the cliff was all that was ever approved to be the boundary line, irrespective of what the maps say. So I don't know whether Macaulay or us are at fault here for filing petitions to rezone it. The problem here, these records were buried. DR 9921, which changed map H59, was not available on your website. It wasn't available no matter where we looked. We couldn't find it. And after a lot of sleuthing, we uncovered that piece of evidence, which points to the commission's decision in 1999 that the maps were wrong. And that's where we are today with this petition.
Okay, and thank you for that explanation. So, Mr. Church, DR 99, are you saying that that's this property or that's another property?
It's 5 miles north of here.
Okay, and that's a difficulty. The only matter that, in the record we're reviewing is your property. I don't know the facts of Mr. Stengel's case, his property, whether indeed it is the same as yours or whether it's different from yours. So for me, at least as the commissioner here, I can only evaluate the facts that have been presented on your case and cannot use Mr. Stengel's property as any kind of a precedent to making a determination in this matter. So I hope you can understand, in my view, the limitations. So while you believe that the Stengel matter may be precedent and the basis for your property, for me, I don't know what the facts in that case were, that I can only evaluate your case based upon your facts. And what I've seen is that everyone who is involved with this property not only believed, they treated it like it was conservation. You went and got a CDUA, you went to DLNR for a CDUA, so did Mr. McCulley. So while there may have been uncertainty about the zoning, all of you acted on the basis that it was conservation land. So I understand the position that you have, and I appreciate the work that you've done on this matter. But I don't know if you've got anything more to add, but I think you've answered all the questions. Well, let me ask you one more question, Mr. Church.
If I may come back first, though.
Okay.
Your rules, I would have put the Stengel decision in here as an evidentiary document exhibit. But your rules say I don't have to if it's an official land use commission record. So I have referred to it, and it's supposed to be available to you. And I've only followed your rules that I didn't. I referred to it. I'm not required to exhibit it, but it is a precedential document of sorts. If you look, if it's made available to you and you look at it under applicable legal authorities, there the commission virtually took a quote out of the report, and it said, in the case where the shoreline is bounded by
I think I'm losing you, Mr. Church.
Yeah, Mr. Church, you faded away.
Yeah. I'm going to try to put my thought back together. The DR 9921, we have cited that. We intend that it be included in the record here for your consideration. And the only reason it's not in our exhibits, it says clearly in our petition that it's not required to be exhibited if it's one of your official records.
Okay, now I appreciate that. I think I would nonetheless would have liked to have, I don't know whether their facts are totally the same as yours. I know we can rely upon other cases for if there's a legal precedent, but one that's factually based, it would be very helpful to see the facts in that case. So at this point in time, I can only evaluate your declaratory action based upon the facts of your case. And let me just ask you one final question, both Mr. Church and Ms. Hedna. If your motion is, if your declaratory action is denied, will you proceed forward on filing a district boundary amendment?
Yes.
All right.
However, we may first choose other legal avenues to explore the petition for a declaratory order.
All right, fair enough. Thank you very much. I have no further questions, Mr. Chair. Thank you, Mr. Church and Ms. Heidel.
Thank you, Commissioner Chang. Commissioners, further questions for Mr. Church or Ms. Hildahl at this time?
Am I able to ask Ms. Chang a question, please?
No, it doesn't work that way in these kinds of proceedings. The commissioners get to ask questions. You can raise a point if you wish to.
Can I raise a point, please?
Yes.
I think what the new thing that Ms. Chang is trying to understand from us is that, do you consider the 1969 report, which contained the actions taken by the LUC for determining conservation boundaries, to be the law? Or do you intend the maps to be the law, even though there's been cases that have shown that the maps were incorrect? That's my statement. I'm sorry.
Thank you very much.
There are other examples where the maps.
Sorry, Mr. Church, I'd ask you to at least
Okay.
say you'd like to add something. It's hard, especially when I cannot see you, to
May
manage
I
the
add
proceedings
something?
well. Yes.
I'm aware of 2 other cases that have come before this commission. One was Stengel, one was on Oahu. And there the map was found to not be right. And in both cases, the commission said that the words of the proceedings in those days had at least equal, if not more, meaning than the maps. So in 2 cases I've found so far where the maps were found to not be the final document. I'd be happy to cite the other one if you want me to look it up.
You may raise it later. Let me check in with the commission. Commissioners, do you have further questions for Mr. Church or Ms. Hildahl at this time? Commissioners? I have one question at this time. And it has to do, so it's looking at this from a very different angle. Mr. Church and Ms. Hildahl, more from the angle of the way we process declaratory ruling petitions. And the Land Use Commission, the Hawaii administrative rules describe how we can consider and when we can consider or deny declaratory ruling petitions. And one of the considerations that we have in front of us is whether the action, and give me 1 second while I pull up the exact language. So under HAR 1515-100A, the Commission for Good Cause can deny a petition and refuse to issue a declaratory order under 4 circumstances. And one of those circumstances is the issuance of a declaratory order may affect the interests of the Commission in litigation that is pending or may reasonably be expected to arise. So one question I have regarding this is whether or not the situation you find yourselves in your property is unique to your particular area, or indeed, are there a large number of other parcels on the coastline between Hilo and Hamakua that are currently in the conservation district that if the Commission chose to rule and grant the ruling that you're seeking, would suddenly be considered to either be now in the agricultural district or possibly have been previously restricted from uses by being determined to be in the conservation district?
So we don't know.
You understand my question?
Yeah, I would point that so far, we're only the second party in 50 years since this first boundary amendment went through. It's been 20 years since the last party came before you in this. So it's not for us to decide. And I don't know that you would be litigated. There might be other people that are asking for their own boundary interpretation based on the same factors. We don't know.
Thank you for your response. I don't have anything further at this time. Commissioners, anything further? Ms. Kato, may I check in with you? How long do you think your presentation will be?
About 5 minutes.
Okay. Why don't we roll into your presentation and then we'll take a recess and then we'll come back for questions.
Okay, thank you, Chair. Well, the Office of Planning and Sustainable Development would have no objection to Land Use Commission's granting of petitioners' requested declaratory order, interpreting the boundary to be located at the top of the Sea Poly. And the question here is where the conservation district boundary was intended to be drawn at the time it was established. And the first state land use district boundary review was completed in 1969, and it designated a band of coastal lands around the island in the conservation district. The report, however, did not clearly state or map out in detail where the boundary was for any particular land. It did so just in broad scopes and on conditions. As such, the location of the boundary has to be identified by applying the guidelines in the 1969 report. The 1969 report discusses the intent of where that conservation district was intended to be. And the report states generally that the polylands of the Hamakua Coast are included in the conservation district using the ridgetop as the boundary, and that land in agricultural use were excluded. There were, however, many deviations from the general standard for various reasons, including specific features such as a road or other physical features. And the report on page 86 lists out 4 specific conditions to be used in determining the conservation boundaries in shoreline areas. And I believe 2 of those conditions are relevant. One of the conditions states that where the shoreline is bounded by steep cliffs or a poly, the top of the ridge is used as the boundary. Another condition states that where there's an access way or like a road at the edge of agricultural use within reasonable proximity to the shoreline, then that access way is used as the boundary. For the petition area, there's both cliffs and a railroad right of way, meaning that both conditions could apply, the 2 conditions that I mentioned. Regarding the railroad right of way, however, the condition states that the access way is used when it is at the edge of agricultural use. And petitioner has indicated that at the time of the 1969 report, the petition area Makai of the railway was in agricultural use. And petitioner's exhibits also show that the land was owned by Mauna Kea Agribusiness and C. Brewer and Company. And there's a statement from the sugarcane land manager about the agricultural use on the property. And if this is correct, then the railway does not necessarily match the condition for use as the boundary. So it's less likely that it would have been used. But as I said before, there isn't anything that specifically shows or states what this particular property, where the boundary should be. So it's unclear. And I think it could, based on facts, go both ways. And over the years, many similar properties, similar coastal properties have come before the LUC to determine that the boundary is or should be located at the top of the Sea Poly. And I think due to a lack of clarity stemming from the 1969 report, it's possible to interpret the boundary in different locations. And the LUC and LUC's staff have previously determined that the location of the boundary can be at the top of the Sea Poly for similar coastal properties. And Commissioner Chang mentioned wanting to know about any similar situations. As noted in our written submission, there was a boundary interpretation number 09-19 Murrigan. It's a boundary interpretation for a coastal property in North Hilo. And that interpretation found that the boundary was at the top of Sea Pali. And in that property, a portion of the railroad right of way was also there, which is similar to the petition area. And for these reasons, OPSD would not object to the LUC's issuance of a declaratory order interpreting the boundary to be located at the top of the Sea Pali. Thank you.
Okay, thank you very much, Ms. Kato. We will recess. It's 10:51. We will recess until 11:01. I will note for the record and any members of the audience who are interested, the Stengel declaratory ruling, which was referenced earlier by Mr. Church, is available on the LUC website under declaratory rulings. With that said, it's 10:51. We will recess until 11:01. Mr. Church, are you here? You're on mute.
Chair Sawyer, this is Giovanni.
I'm here.
Okay. Commissioner Giovanni?
Yes, my schedule has changed. I'm now fully available for the commission hearing. I will not excuse myself.
Thank you very much, Mr. Giovanni, Commissioner. And thank you for noting your presence. Mr. Church, I just want to make sure that since we're considering your matter, you're here and available. With that, it's 11:01. We are back on the record. We have just heard from Ms. Kato. If you're picking up leaf blowers in the background on my audio, I apologize. It is among the matters outside my control. But we have heard from the Office of Planning, and now they are available for questions from the commissioners. Commissioners, questions for the Office of Planning. Commissioner Okuda, followed by Commissioner Chang.
Thank you, Mr. Chair. Questions for the Office of Planning, and anyone from the Office of Planning can answer this question. What is the standard of review that would be applied to our decision if we granted the petition or denied the petition? What would be the standard of review on appeal?
On appeal to the court?
Yes, let's say if somebody, an aggrieved party, decided to appeal the decision that we made today, either granting the petition or denying the petition, what would be the standard of review that the appellate court would apply?
Offhand, I'm not sure what the standard review is. I believe generally deference is given to the LUC's decision, but I would need to look up the specific standard of review. I've not been involved in an appeal yet.
Is this a case where it's clear that we would be reversed on appeal if we made a decision one way or the other? I mean, there are some cases where you look at what the factual record and the evidentiary record and the pleadings, and even though nothing is guaranteed in the legal system, you pretty much can predict, hey, if the decision went this way, odds are the appellate court would reverse. Is this the type of case where when you look at the record that's being presented, we are compelled to rule one way or the other based on the penalty of we're going to be reversed?
Well, as I mentioned in my testimony, the Office of Planning and Sustainable Development does not believe that the answer is clear. We don't think that the 1969 report is clear as to where this boundary is located. So I think it is up to the LUC's best determination as to where the boundary of the conservation district was intended to be based on the information before you. So no, I don't think it's clear.
Okay, and so we have the discretion or deference to make the decision. Is that correct?
I believe that's correct, yes.
Now, the Office of Planning and Sustainability, you're basically like the community watchdog. And just to use layperson's description, I mean, is that a fair statement?
I'm not sure.
Oh, okay. Well, let me ask the public policy question, Jen, just to help inform my decision making a little bit. From a statewide public policy issue, and to some extent, this is somewhat a follow-up on Commissioner Cabral's initial line of questioning. Is it a matter of concern to the Office of Planning that some people, and I'm not accusing the churches of this at all, but from an overall public policy situation, that there are situations where people buy conservation designated property because it's cheap or priced lower than urban or rural designated property. And it's with the intention that, hey, I'm just going to do urban or rural activity on that property, but I got it on the cheap, and more likely than not, the government and many times these are the county entities aren't really going to enforce the restrictions. I mean, isn't it true that's really a public policy concern among many of public policy concerns we have? In other words, that people don't really deep down respect the agricultural or conservation designation, that it's like something that maybe we can get around later on down the road.
I understand that concern and the discussion that happened on it today. At the same time, I don't think it's my place to comment on policy matters. And I think that the immediate question before the LUC on this declaratory order is a legal one. It's a legal interpretation of where that conservation district boundary should be. And I don't think it's a question of policy.
Well, in making a legal determination, is the LUC precluded from taking into account what might be the underlying factual situation? And the reason why I raised that is, just a while ago, as you probably are aware, we were faced with what I would describe as a somewhat technical argument being made to allow short-term vacation rentals on agriculturally districted land. Very cogent technical argument. But it in my view required looking at what is really the reality of going on. In making our legal determination, are we supposed to shut our eyes to the reality of what might be going on?
I'm not too sure how to answer that question.
Okay, no, that's fair.
I understand that you're just going to consider what you're aware of and what you hear, but in terms of this legal question, it is really a legal question, as opposed to like a DBA, which is a policy matter.
Well, if we have, and I'm just speaking for myself, if I were to have a concern that this legal question might have factual implications, or to put it in plain English, there might be a lot more going on than simply a legal question. Would I be erroneous to the point where I get reversed on appeal if we said maybe the records gotta be fleshed out more in detail, either by scheduling the matter for a hearing or maybe taking it up on some other matter that's already pending? I mean, would I be totally crazy to come to that kind of conclusion that, hey, when we're dealing with important lands like conservation, or we're dealing with agricultural lands, something that the Constitution has, given special protection and recognition, maybe we better make sure we have a complete factual record so that, there's no question what's really going on. In other words, maybe, flesh the record out. Would I be totally wrong to the point where I get reversed by the Hawaii Supreme Court?
And Commissioner Kuda, I apologize. I don't think that I can necessarily answer that.
Well, okay, no, that's fair enough, fair enough. Thank you, Mr. Chair. I have no further questions.
Mahalo, Commissioner Okuda, Commissioner Chang, followed by Commissioner Ohigashi.
Okay. Thank you, Mr. Chair, and thank you, Ms. Kato. I just have a couple of questions. Is the Office of Planning's position that you support the church's declaratory motion for declaratory action, or are you, we would call it sort of in Hawaiian, kanalua, are you, you could go either way?
It would be either way.
Okay.
We think that's unclear, so we think that it's up to the LUC's discretion.
Okay, that's helpful. So even, okay, that's helpful. So, because I want to follow up with the line of questioning by the chair. If the LUC acts on the church's petition, because the churches are essentially saying an error was made on the map.
Mm-hmm.
And so if an error was made on the map for the church's property, then an error was made on the map for all of the properties along this strip, or for who knows how far, but whatever the maps that were made at that point in time, an error was made. Do you know how many properties where this same situation applies to?
I do not know that, but also each property is different. So, I would not be aware of how many properties are exactly the same. And as I mentioned before, there's general standards, but there were also many deviations from that general standard. So, some properties may have had a road, and some properties were in agricultural use, some were not.
Okay. But wouldn't you agree that if we accept Mr. Church's argument that a mistake was made, and that we go back and we change it to grant the declaratory action, that there could be other properties along this area who also come back and say, well, a mistake was made, or it affects their property in one way or the other?
Yes, but at the same time, this is not the first case where a similar property has had this determination.
Yep. Okay. And are you referring to the Stengel property?
There's the Stengel, there's the boundary interpretation that I mentioned, Murrigan. That one also determined that the boundary was at the top of Sipali.
Okay.
And
But
we
even-
don't know if there are others.
Right. And I guess that's my point. You were all relying upon, setting as precedent a few cases, but yet there hasn't been an exhaustive review of other properties which may have taken a totally opposite interpretation. Notwithstanding the top of the Pali, it may still be zoned agriculture. Have you surveyed other properties that have had the same issue related to top of the Pali, where all properties where the boundary is top of the Pali, that's the line between conservation and agriculture?
I'm not aware of this.
Okay, so that's the issue that I'm having with sort of this picking of these cases, because you're asking us to rely upon them as some precedent, but there hasn't been an exhaustive research of other properties where they may have had a different interpretation or different result. Because in looking at the Stengel case, the facts seem to be different here. The facts seem to be different. There was no reliance. There was no previously at least three DBAs that were filed in the Stengel case. Theirs was purely an interpretation of top of the poly. And I don't know what all the other facts are on the Stengel case, but just kind of reading that, it seems to be, I question the reliance on that to in some way suggest that's precedent for the church's case, the church's situation.
Well, we have not said that that's precedent for this situation.
Well, you've said that that's an example that where we've done the same thing.
I'm saying that those are examples saying that the matter is unclear and that the LUC has gone both ways on where this determination of the boundary is.
And
for similar properties.
I'm sorry, have you submitted any other properties where the LUC has gone the other way?
Well, for example, the Barry Trust, that was a DBA. So in the DBA, the boundary was interpreted to be, or not interpreted, but automatically assumed to be more inland. And in that case, for policy reasons, it was changed because it was a DBA that was done based on policy reasons. It's not saying that there was a mistake, it's saying that we're moving the boundary line. So that one, in that property, which is a similar coastal property, the boundary was inland.
Yeah, I think that was factually very different. I mean, they filed a DBA because it was in conservation and they wanted it to be moved to ag. So there was not a question. I mean, and you're right. I mean, I think that whole subdivision, most of the properties weren't ag, but I don't know if I would rely upon that Barry case as being a similar to this church's case. But I was assuming that you cited those cases for purposes of saying that they are in some way similarly situated to the church case, and we should look at those cases as in some kind of a that they set some. I interpreted your reliance on those cases or listing those cases as suggesting that Land Use Commission should use those as examples for similarly situated cases. Is that correct? Is that what you were using them for?
That is not correct entirely.
Okay, I'm sorry I interrupted you. Go ahead, explain to me.
Sorry, OPSD's position is based on the 1969 report. And based on our review of the 1969 report, we don't think that the boundary is clearly at the top of the poly or clearly at the railway or any other particular location. And we just included those cases to show that it is unclear and to give you some examples of similar coastal properties and indicate, the history of the area. But if you're asking about individual properties, that is really a case-by-case basis because properties have different characteristics. I'm not sure what it would take to actually go through all of that. And also things like the boundary interpretation that we included, the Murrigan one, that is not available on the LUC website. So I don't think boundary interpretations are necessarily even available or readily found. I think the Stengel case, even though that was a DR, I don't believe that was also either available or easily found.
Okay,
So,
and all right, I'm sorry. And I guess that in my questioning with the church, You know,
Mhm.
for me as a commissioner, I have to look at it factually specific. So that's why when I read you OP's statement and your reference to some of these other cases, I perhaps misinterpreted your intention for using those cases. But you would agree that it's factually based. It's what's presented to us by the churches in their particular matter. All right. Thank you, Ms. Kato. I have no further questions.
Thank you very
Yeah,
much, Commissioner Chang. Commissioner Ohigashi.
I have a few questions. I'm not clear, Ms. Kato, about what you just relayed to Ms. Chang, Commissioner Chang. If we grant this interpretation by the churches, does this declaratory ruling affect any additional boundaries in that particular area?
I do not think so. I think it's an individual property by property determination.
So if we do that, that would mean that we would be redrawing in that particular area, a sort of like a bump. Is that right? That we would create a hump or a bump. Is that right?
I have not looked specifically at it, but I believe that the line is already, back and forth, depending on the property.
In other words, we would be creating an additional area that is under agricultural zone. Is that right?
If you were to grant this declaratory order, that you would be deciding that in 1969, it was determined that this was supposed to be agricultural and not conservation.
Would it have any effect therefore then on the adjacent properties in that area?
I don't believe that it would.
So our declaration is purely for that particular property and cannot be used by any other property. Is that right?
Again, like the other cases that I mentioned too, it's just an example or something to consider. I don't think that it would automatically change anything with respect to neighboring properties.
Now, do you know what permits that the DLNR has given or denied on that particular area for the church property?
I have generally read about it, but I am not that familiar with it.
If we were to make this declaratory ruling, would that affect any of the DLNR permits that have been issued?
I'm not sure. I'm not familiar with the DLNR permits for that process.
Now, one of the things that I was curious upon is that your review is that the boundary interpretation done by the LU staff in 1992, is that you believe was not clear? Is that what your belief is?
Sorry, what are you referring to?
I'm referring to in his petition. I think he refers to a 1992 boundary interpretation done by the land use 1992 boundary interpretation done by the Land Use Commission executive officer at that time. You recall that being mentioned?
Are you referring to the specific property that
Yes.
the previous owner McCully?
Yes. And he received that.
Yes.
Right? That interpretation, boundary interpretation.
Yes.
Has the Office of Planning determined what factors went into the boundary interpretation done 1992 for Mr. McCully?
That interpretation appears to be based on the assumption that the railroad right of way is the correct boundary.
Would it matter in OP's review whether or not that the boundary interpretation was done by using an official land use quadrangle map H-65? Would that matter?
I'm sorry, would that matter in,
Yeah, that it came from the official quadrangle map for that area.
I understand that there's a map that was used, but whether that map is correct or not, I don't know.
But it was the official land use commission map that was adopted by the land use commission.
I understand that the map is not entirely clear and it's a very general line drawn.
That's
on-
not my question. My question is, was it adopted by the land use commission?
I believe
know.
so. But I don't think the map is clear.
And also, as part of the interpretation, didn't Mr. McCauley submit meets and bounds survey of the property and district boundaries?
I don't recall exactly. Perhaps someone from OP could answer.
Is that part of you? Would that be part of the Office of Planning's review in this matter to determine what exactly went into that determination? Or did you just look at the map and say, oh, it looks vague, so we're deciding?
No one knows.
I'm sorry, could you repeat the question?
My question is very, admittedly, it's a compound question. It started off at the beginning as what did you guys review and whether or not you took that into consideration. And one of the things that I was concerned about was that the landowner at that time in 1992 would have to have provided information concerning meets and bounds and a survey and the district boundaries in it. And they would provide that for land use commission staff to review. And according, would that information factor into your question as to whether or not that determination in 1992 was unclear or needs clarification?
I understand that information is provided to the LUC. And
Ms.
the
Kato,
LUC staff.
Ms. Kato, I'm going to recognize that your client has raised their hand and might wish to respond to this line of questioning. Let me swear you in, Mr. Funakoshi. You swear or affirm the testimony you're about to give is the truth?
Yes.
Okay. You wish to respond to the question from
yeah.
Commissioner Hikashi?
Yes. The Office of Planning does not review boundary interpretations as a matter of course. This is the role of the Land Use Commission's administrative staff. So we do not review those, only review, of course, boundary amendment petitions and other matters that come before the commission, such as this one. But typically we do not review boundary interpretations.
Please continue, Commissioner Hikashi, to either.
I'm not sure, Mr. Funakoshi, if that answers my question. My question is really is that you came up with a conclusion that it's unclear, given the maps and status of that particular line. The question that I really have is that in 1992 there was a determination of a boundary, or where the boundary was, interpretation of a boundary, and I'm asking, did your finding about the unclarity of unclarity in this situation did you review any of that, of the documents or process that the Land Use Commission Executive Director 1992 went through in order to determine where that line is and make a determination whether or not his determination is unclear, needs clarification?
I don't think we did review whatever correspondence was provided by the executive director relative to the boundary interpretation, but we did not examine in detail the process that they used to arrive at that.
That's important. Thank you.
Anything further, Commissioner Higashi?
Yeah, I just have just a few. Scotto, was there a difference between the Macaulay meets and bounds locations of the railroad right of way and the meets and bounds description of provided by the churches, if you know?
If there's a difference in where the railroad is located?
No, I'm talking about,
or
in order for the question that I have, in 1992, Mr. McCully submitted meets and bounds and descriptions and showing where everything is and where it's supposed to be and boundary areas and things like that. And later on, the churches provided some meets and bounds descriptions. Do you know if they match or if there's any discrepancy in them?
I have not compared them, no.
Would that be important in determining whether or not this petition should go forward or not?
It depends on if that's relevant to the conditions that are referred to in the 1969 report. What is the factual thing that you're trying to get out of that meets and bounds description?
So if there are discrepancy as to where the former railroad right of way was and where the other items were in terms of the Macaulay meets and bounds versus the churches meets and bounds, that would depend upon how it relates to the 1969 report.
So you're saying if there is a discrepancy in or disagreement over the location of the railroad right of way?
Yes.
I'm not sure if there is a discrepancy or if that would be applicable.
I'm just asking if there was. If there was, would that be relevant?
I'm not aware of any disagreement as to where the railroad is.
That's all the questions I have. Thank you.
Thank you very much, Commissioner Ohigashi. Mr. Church, I'm going to note procedurally, I see your hand raised and I see you were trying to interject into the conversation. So the Land Use Commission is questioning the Office of Planning. You will have a chance to respond to statements by the Office of Planning after we're done with the Office of Planning and we turn to you for any concluding statements and questions from the commissioners. Is that understood, Mr. Church? You're muted, so if you understand, you'll need to indicate so or don't understand by unmuted. Mr. Church?
Yes, thank you very much.
Okay, thank you. I'm going to lower your hand then, unless you do it first. And commissioners, are there further questions for Ms. Kato or Mr. Funakoshi at this time? If I see none, I have a couple, and I will leave it to you, Ms. Kato, to direct whether you will answer them or Mr. Funakoshi will answer them. The first question is, I've noticed in these proceedings that the reference to Hamakua is perhaps used in a couple of different ways. Some saying the Hamakua coast might be referring to the entirety of the coastline between Hilo and Waipio, and others referring to strictly the Hamakua Moku versus the North Hilo district. In which district does this property lie?
To be honest, this is a question that I have tried to figure out, but for our purposes, we are considering this property lie along the Hamakua coast. But regardless of whether it does or not, if you push that aside, there are those 4 conditions that I mentioned that are supposed to guide where the boundary is supposed to be located. And if you look just at that, then that one says, I noticed, I think from Hilo to another location in the general overall segments, it mentions a 300 line, but in the considerations, the 300 mark is only considered if there are no other physical features that are applicable. But in the case of this property, there's the poly and there's the railway.
Okay.
So I think those physical features have to be considered first.
But you're not suggesting that in this case, those, or other than the railway line, there's another physical feature that should be considered?
No,
Okay.
not that I'm aware of.
Okay. You stated earlier in response to a commissioner's question that the maps are unclear. And I would suppose specifically you mean map H65 is unclear. In which way do you believe map H65 is unclear? Because it's posted to the LUC's website and I'm looking at it. And I realized that if you were trying to perhaps determine the specific location of the railway, that, yeah, you might want to drill down to a location, but the line on map H65 does not, generally speaking, stick to the cliff top, which you can see by the contour lines, but rather is inland, apparently running along the railway line for the entirety or nearly the entirety of this map. So I'm not sure in what degree or in what way you are saying that H65 is an unclear map.
I think it's a very small map, so it's a little hard to tell exactly where that line is drawn, but I also believe that if you determine that it wasn't the intent to draw the boundary there, then the map could be wrong. And that has been found in other cases where they've determined that the map was drawn incorrectly in relation to the intent.
But was that only in relationship to the location of the poly rather than the location of an interior road or railway line?
You mean?
When you say that the LUC has determined that the map is not conclusive and a further determination needed to be made, was that not only in cases where the boundary in question was clearly set on the map, intended to be set on the map at the top of the poly? Whereas on this map, from my just plain reading of the map, or rather the digital reproduction of the map on the LUC's website, if the line was to be drawn at the top of the poly, in all cases, it wouldn't be significantly inland throughout most of this section of coastline.
My understanding is that these maps are based on the 1969 report.
I'm going to politely try to push a little bit more so that you answer my question.
Sorry, I think
I'm feeling like you're not answering my question. And if I've been unclear, I will try to restate. You said, correct me if I'm wrong, the LUC has previously reinterpreted the boundary because the maps have been unclear. Is that correct?
I believe they've interpreted the map where they believe it's being correct.
Okay. And in those cases, was the location of the line in question on those maps solely intended to locate the top of the pulley?
You're asking if the line was at the top of the
In
pond.
the cases where the LUC chose to essentially reread the map, were in those cases where the LUC was rereading, was the line in question at the top of the pulley, at the top of the cliffs, rather than at, for instance, a railway line?
If the line was already there before or it was determined to be at the top. Of the pond.
I will go all day to help you understand my question.
I have
You-
not, I'm sorry, please go ahead.
You are citing to previous cases where the Land Use Commission has said the boundary line was incorrectly drawn on the map. And we are now reinterpreting it based on a more detailed look at topographical features. Is that correct?
I think so.
Yes or no would be great.
Yes.
So in those cases where the LUC has taken that action, was the line on the map trying to indicate the location of the top of the pulley? What I'm trying to get to, Ms. Kato, is that in this case, it appears to me visually that the line on the map clearly indicates over most of this coastline a desire to place the boundary at the railway line. And so I can understand on a map where things become close together. Mr. Church, will you please mute yourself? Where lines are close together that like, oh yeah, I can understand on a map of this scale exactly where the top of the cliff is questionable. But in this case, the line is well inland from the cliff. And I'm not sure that any of the cases that you suggest are comparable are cases where the line was well inland from the cliff.
Actually, someone from Lorraine from OPSD would like.
Yes, if can you turn on your camera if possible, Ms. Maki? Hi, aloha, do you swear affirm the testimony you're about to give is the truth?
I do. Okay, I don't know if I have what you're looking for, but if you look on our one of our exhibits, I think it's OP Exhibit 4, that was a boundary interpretation, not a reinterpretation, which is pretty similar to the original 92 McCulley interpretation, but it does indicate that the top of the pulley was used as the boundary. Did you have anything else?
But my question is, here, the question is not, if I understood the Office of Planning's argument correctly, as represented by your counsel, it was, hey, you've done this before. And what I'm trying to say is, I think I see a difference. When we've done it before, it's been about where the top of the pulley is, not where the railway line is.
I disagree with that.
Okay.
But as we have cited those two cases, which are similar, and but Stengel is okay. So Stengel was a boundary interpretation first, and then they filed a DR.
Yeah.
Okay. I don't think it was a railroad right away, but it was determined to be inland of the top of the pulley at first in a boundary interpretation. And then during the DR position, the Stengel one, they indicated that there was agriculture being done in that area. And so it was
I-
reinterpreted to be the other part.
I understand that, but
Okay,
I agree with you. In the Stengel case, there's no mention of a railway line as being potentially the location of the boundary,
okay.
which is the point I'm trying to get to.
Are you asking
Oh.
if there's a case that's exactly the same as this one?
Yes, if you're going to make the argument that the issue revolves around the map being drawn wrong.
I don't believe there's a case that is exactly like this one that we are aware of, that the LUC has determined where the line was drawn inland and they decided to draw the line, that the line should have been drawn at the top of Sea Poly that has a railroad.
Awesome. Thank you so much. That's
I hope
very
that
helpful
was
clarification.
accurate.
Yeah.
Is that clear? Okay.
Okay, next, and sorry to belabor this, but what would Commissioner Giovanni?
I think that was a very important point, and unfortunately, Ms. Cato's remarks were not clearly heard by me. Could she repeat them?
We are mentioning these cases just to present examples of possibly similar properties or similar situations as best we can to help you in deciding this particular situation, but we are not aware of another property that is exactly the same as this, where there was a boundary interpretation that said that this boundary is drawn wrong and it's supposed to be at the top of the poly. I think in the case of the Murrigan one, possibly the line was already drawn at the top of the poly and they wanted a boundary interpretation, but I'm not, to clarify this, but I'm not sure. I'm sorry. I'm not sure if that was clear.
Commissioner Giovanni, did you get that?
I just want to be sure. So, Ms. Cato, you're saying you are not aware of a reference or a prior case where the boundary was drawn at the equivalent of a Malco equivalent of a railroad, and the interpretation was adjusted to the top of the poly.
I'm not aware of a specific case like that,
So there is no reference. Thank you.
but I also don't have access to all the boundary interpretations and I have not gone through them. So
Well,
I
you're not
don't
aware-
know if there is or not.
Okay, so you're not aware of any that are on the record in this matter.
I'm not.
Thank you.
Ms. Cato, and if you're not aware, you can answer you're not aware. Is there an appeal process available for boundary interpretations?
Yes, boundary interpretation is a declaratory order.
Boundary interpretation.
That I'm not sure. I think there may be.
Would there be a deadline associated with an appeal of a boundary interpretation?
I would need to look up the rules on boundary interpretations.
Is there, I mean, in some ways, would you agree that the motion before us could be read to be a late appeal of the Macaulay interpretation?
I'm not sure on this. OPSD is not involved in boundary interpretation, so I'm not really that familiar with the exact process of it. I would have to look this up.
Okay. Thank you, Ms. Cato. I guess I have one last question. If in hearing, and you responded to Commissioner Chang and saying, basically it's a Kanaloa kind of situation. We could go either way, right? What compelling facts are presented in this case that would cause us to interpret that the boundary should properly have been, to try and, if I can, state the church's case, that the boundary has always been Mauka of the Pali rather than Mauka of the railroad line? What compelling information or facts do we have here that indicate that is the case?
Well, I don't believe that we're saying that there are compelling facts. because we're saying that we're not clear on which is the correct boundary location. So
wouldn't you turn to the map?
so it's not necessarily, well, our
As part of the
position,
record?
our position in saying that it's unclear is based on the possibility of which conditions likely apply. And in some cases, it's been assumed that the railroad right of way is the correct location, but the petitioner has provided evidence that the properties past the railroad right of way were used in agricultural use. And according to the condition in the 1969 report, access ways like the railroad right of way are used where it's at the edge of the agricultural use. But the records indicate that that was not the edge of the agricultural use. So it makes it less likely that that railway was used or should have been used based on the boundary review report. In which case, there's
But
another.
was used or should have been used are two really, really different things, right? Was used means we're saying they used the railroad, or should have been used, is saying they used the railroad boundary, but they shouldn't have done it. So we're going back in and we're questioning what they did. But that's, I think, different than what the churches have argued, which is they actually used the cliff boundary here, and past interpretations have been incorrect.
I'm not sure what they used in 1969. I understand that I believe the maps are from a later time.
Okay.
The maps that were later drawn based on the report.
Yeah, you're correct. I have
So I'm not
nothing.
sure.
Thank you. I have nothing further at this time. Commissioners, anything further? It is 11:52. We've been going for another 51 minutes. What we have left is any final statements from the churches, any final questions from the commissioners, and then deliberation. We could take a break now for 30 to 45 minutes for lunch and proceed with this, or we could try and power through before lunch to close this matter and move on to the Kihei High School matter. What is the commission's pleasure? Commissioner Okuda?
Thank you, Mr. Chair. I was trying to indicate my recommendation, we power through.
Commissioner Giovanni is thumbs up.
Yep. Chang too.
Commissioner Chang. Anyone seriously concerned with that? If we go past a half hour more, I will stop it and we'll take a break no matter what. Okay, let's continue then. No further questions for the Office of Planning at this time? If not, Mr. Church, you may proceed with your final statements.
Well, there was a useful piece of information that could have been inserted earlier, and it would have saved us the last hour of discussion. If you look at the 99-21 decision and order, the commission ordered that the entire map be changed. The entire map.
Whoa. I'm not sure what happened there, but you got to go back. We got a very loud sound across the mic from you.
In the Stengel case, commission didn't just rule his property. They ruled that the entire map H59 be changed, and it was. And then come along the Merengue, I believe, group in 2008, and they lived, down the coast, closer to me. And the commission cited in their boundary determination interpretation, that prior ruling and said map H59, the Papaloa quadrangle, the whole thing is the top of the cliff. And if you look at H59, you will see that the boundary pretty much follows the top of the cliff now. In other words, the map was changed. And I'll throw out one other thing. During 2005, or 6 actually, Laura Thielen, then the, I want to call her the director of the Office of Planning,
That would be correct.
testified during the McCulley's petition. And she said, and I can find the exact reference and page number given a few minutes, but in so many words, she said, look, to the commission, she said, we didn't go out and inspect anything. Not only didn't we, the fact is, all up and down that coast, the lands weren't inspected. And my petition here says, in other words, commission accepted that and changed the Stengel map in its entirety. They just didn't change the other maps. And the report clearly, I can take you through the pages on the report and what they say. Those 4 conditions for determining where the boundary should be is their recommendation to the commission before that meeting in the county of Hawaii on July 14th of 1969, where it was examined at the community meeting, and the resolution was the top of the cliff was to be it from that point forward. In other words, they looked at the recommended map. It was the final recommended map. The report refers to a whole bunch of maps that were going back and forth, and OP even showed 3 of those maps in their testimony during McCulley's 2009 petition. There were more than 1 map, but the final map went to the community meeting, and that's what is described in the report. And then the earlier section I read to you said basically the text of the report is to carry the same weight as the maps. I will read the order that the commission, at least part of it,
Mr. Church, other than responding to any questions that we may have, this is your chance to say anything else that you want to say on your petition in front of us. This is your chance. So please don't hold back if there's something you wanted to include. Okay. So please continue.
So that decision and orders, I'm not just telling you they changed the entire map. Their order says that. Accordingly, this commission determines that the state land use district's map H59 be amended to reflect that the property Mauka of the top of the ridge or Pali is designated within the state land use agricultural district. And the whole map was changed, and there's a reference to it in the bottom left-hand corner of the map, that decision in order. And along came Morangi and the Land Use Commission looked at that map, and then they looked at the bottom corner and said, oh, the top of the Pali is it. Again, I point to Thielen's testimony. For state OP has tried hard to explain how these maps don't seem to agree with what happened in these meetings. And they list these 4 conditions, but those were the conditions that the Land Use Commission or the report's authors explained to the meeting how they came up with these lines on the map. And the public, and I'm reading between the lines, somebody raised hell and said, all of that land is being cultivated for sugarcane right up to the top of the cliff. So the commission approved that the top of the Pali be the line. And less than a few weeks later, the maps were approved as final, and the minutes of the meetings are approved as final, and they're in contradiction. And my only explanation is they never intended that the map be final. They intended that the record of the report be final. In other words, the record of the meeting in Hawaii County on July 14th, 1969 was to be the final record of where the line was supposed to be. And no one bothered to change the map because they assumed the report would be the official record. And that's most of what I want to say right now. There is one other thing. If you look at the map of H65, which is where we are, there is a bold line on the top of the map, or on the top of the poly, all along there. And that USGS map dated back, I think, in 1948, if I recall correctly. In the bottom, it says something like that. In other words, the top of the poly has been available right from the beginning for these people to have drawn their lines on the map. It just simply wasn't changed because, you know, they were dealing with all of Hawaii. In a matter of a few weeks, they were dealing with all the coastlines of all of Hawaii and going back and redrawing the maps, I don't think, and going out and actually seeing if this land was in ag or that land. I don't think that was a practical option. So they relied on the report. And, you know, if you go through the report, you can see in various places where whatever the recommendation was, it was partially approved, denied, etc. in those chapters 4 through 7, which is the official record of the meetings. This is, I'm sure everyone's confused, but after I've read this thing like 100 times, that's what it says. And I think that's sort of what Allison was saying. She's referring to those 4 conditions, but if you go to the chapter where those 4 conditions are listed, at the beginning of that section, and I think it was section 4, it describes their recommendations. It doesn't describe what happened at the final meeting. So I'm open to questions.
Thank you, Mr. Church. Questions, commissioners? Any questions for Mr. Church? Seeing none, am I correct? I'm seeing no further questions for the petitioner. I indicated I would provide an opportunity to ask additional questions of the Office of Planning of Law. Are there any other additional questions for the Office of Planning?
I'd like to make a statement if possible, the petitioner.
I'll allow it. Please go ahead.
Thank you very much. I think we're disregarding Ms. Maki's testimony that if the road or the railroad was at the Makai end of the ag use, conservation was used. But if it was at
You faded out, Ms. Hildahl, all of a sudden. There we go.
Ms. Maki was interrupted when she was trying to describe that if there was ag use all the way up to the top of the poly, that the top of the poly should have been the boundary between the ag and the conservation district. I think this is one thing that we need to pay attention to. And also the whole question here is if you consider the 1969 report, which contained the actions taken by the LUC for determining conservation boundaries, should that be the law? Or should the map be the law, which had already, there's been several cases which determined that the map was incorrect. That's all. Thank you very much.
Any further questions for Mr. Church, Ms. Hildahl, or any of the parties? Going once.
If I
going
may,
twice. Okay, you concluded. I'm gonna, this is it.
okay, okay.
You could give one last statement, and then I especially hard when I can't see you due to your limited internet access to know that you're going to keep jumping in. So you may make a final statement.
I can't call up my exhibits on the screen for you to look at. I'm sure someone on your end can. Exhibit 9 is the field map that actually shows how much of the field was on one side of the railroad and how much was on the other. So if that's useful, you can refer to that. Exhibit 9.
Okay. There being nothing further from the petitioner, we will, and no further comments. Any final comments from OP?
No, Chair, thank you.
Okay. So we're going to proceed to decision making or deliberation at least. So I'll remind everyone here, petitioner OP, as well as members of the audience, this is a hearing on a request for a declaratory ruling. As such, the decision of the commission will be made on the written briefs on file and posted to our website. It's not an evidentiary hearing, but any oral presentation made today and any public testimony will be considered by the commission in our decision-making process. According to the commission's administrative rules, section 15.15.100, within 90 days after receipt of a petition for a declaratory order, the commission shall either deny the petition in writing, stating the reasons for the denial, issue a declaratory order, or set the matter for hearing, as provided in section 15.15.103 of the commission rules. In addition, section 15.15.102 of the commission rules provides that the commission for good cause may refuse to issue a declaratory order by giving specific reasons. The commission may so refuse under the following circumstances. One, where the question is speculative or purely hypothetical and does not involve the existing facts or facts which can be expected to exist in the near future. Two, the petitioner's interest is not of the type that would give the petitioner standing to maintain an action if the petitioner were to seek judicial relief. Three, the issuance of the declaratory order may affect the interests of the commission in a litigation that is pending or may reasonably be expected to arise. Or four, the matter is not within the jurisdiction of the commission. The commission will now conduct formal deliberations on this matter, and I would note for the parties and the public that during our deliberations, I will not entertain any additional input from the parties or the public unless those individuals are specifically requested to do so by the chair, and if called upon, I would require that all comments be limited to the question at hand. Commissioners, let me confirm that each of you are fully familiar with the record. You've reviewed the record and are prepared to deliberate on the subject docket. After I call your name, please signify orally with either an aye or nay that you are prepared to deliberate on this matter. Commissioner Axon.
Aye.
Commissioner Cabral.
Aye.
Commissioner Chang.
Aye.
Commissioner Giovanni.
Aye.
Commissioner Okuda.
Yes.
Commissioner Wong.
Aye.
The chair is also prepared to deliberate on this matter.
Chair, this is Commissioner
Commissioner
Wong.
Wong.
You forgot Commissioner Ohigashi.
Excuse me, I apologize. Thank you for that correction. Commissioner Ohigashi.
I'm thinking, yeah, aye.
Did I miss anybody else? Commissioner Okuda, I got you. Okay. Thank you for that clarification. With that, we are prepared to deliberate. Commissioners, what is your pleasure? let me, I guess. Oh, Commissioner Cabral.
Thank you, Chair. I'm not elegant enough to put together the right motion, but I do want to voice my opinion that I'm a layman. I'm not one of these elegant attorneys like so many on our commission that I appreciate their ability to say it in the right way, but I'm extremely uncomfortable over the thought that we can, should, or even have the right to be changing property lines, as well as I'm uncomfortable with the idea that we would change history. There on our island here, there are a number of times where, in fact, the poly does move. I hate to tell that, to add that to the mix. We drop off land with erosion on a large number of times. I've sold land that 20 feet of it is out in the air because the land apparently used to be there because it was at one point surveyed, but it's no longer there. And I've had to even on title clearances go back and have documents interpreted in Hawaiian that are extremely old. So this idea that we would go back and change history makes me very uncomfortable. And I'm not saying that legally that's the correct thing, except that I don't feel that we have that right or ability. And I'm also, I guess, confused too. First, when the churches came to us, which I was on this commission for probably 3 years ago, because it was pre-COVID, we met in person. Their idea was to take their conservation land and get it into agriculture. Now with this hearing, that has shifted. And I was more ready to go with that decision, but now that's not the question. So I would, if someone's ready, I would like to, in some proper motion, deny the current request in front of us to go back and change history. Thank you. Help.
Thank you, Commissioner Cabral. I'm going to frame that as a discussion point rather than a motion per se, but you certainly indicated where you're leaning.
Yes, thank you.
I was going to say before you jumped in, we've had the opportunity, and to be honest, while it's been longer than we've liked at times, to interact with the Mr. Church and Ms. Hildahl for a number of meetings over a number of years. I have grown to deeply appreciate their determination in putting their property to productive agricultural use, to try and make a government process work in a way that they want it to work. And if it is not today, I am hopeful that we will get to consider matters, including their other pending petition, in a way that we can hopefully, within our bounds and rules, achieve what they seek to achieve ultimately, which is the productive agricultural use of their land. Commissioner Okuda.
Mr. Chair, I make a motion to deny the petition.
Would you please detail that motion, Commissioner?
Yeah, Mr. Chair, you want me to state the reasons for that?
Please.
Well, can I
Okay.
second that first before he goes on? Because I could have been that eloquent. Thank you, Commissioner Okuda. I second that motion.
Okay, we have a motion made by Commissioner Okuda and seconded by Nancy, Commissioner Cabral. Commissioner Okuda, would you please speak to the motion?
Yes, thank you, Mr. Chair. The law HRS section 91-1, parent 5, either itself or by implication indicates that the party initiating the proceeding shall have the burden of proof, including the burden.
Sorry, is that
Either-
my side? Commissioner Okuda, at least on my side, you totally froze.
Oh, okay.
Party has a burden of proof.
Yeah, okay. The party has the burden of proof, including the burden of producing evidence, as well as the burden of persuasion, and the degree of or quantum of proof shall be the preponderance of the evidence. Okay, either.
You've frozen again, Commissioner. And I'm seeing the other commissioners' movement, so I think that it is just, okay, try again. Sorry,
Okay,
Commissioner Okuda.
can you hear me? I'm sorry. Okay. HRS section 91-1, either itself or by implication, makes it clear that the party that's initiating the proceeding has the burden of proof, including the burden of producing evidence, as well as the burden of persuasion. Okay, and the burden of proof, according to the statute or by implication, is the preponderance of the evidence. In this case, I believe the record that has been presented to us, it indicates that the petitioners have not met the burden of proof. That is demonstrated by the statement by the Office of Planning itself that this could go either way. And because of the fact that reasonable people like the Office of Planning, which has the charge of protecting the public interest and the public trust, itself has made the statements that it's made.
We lost you at the statements that it has made.
The statements that is made, although I understand and recognize the other arguments or statements the Office of Planning have made, is indication that the burden of proof has not been met here. There's also a question in my mind about whether or not this issue is speculative in the sense or because of the fact that there is not, in my mind, by a preponderance of the evidence, indication that there will be bona fide agriculture that would really take place. If there is no bona fide agriculture that in fact will take place, and by the word bona fide agriculture, I mean agriculture that under the statute and the LUC decisions will show that the dwellings are in fact a farm dwelling producing income, not simply personal consumption of agricultural products. If we don't have bona fide agriculture, then it's a speculative, theoretical discussion here. I join in Commissioner Cabral's description of the fact that granting the petition now would bring actually uncertainty onto maps that have been relied on. I believe that there is a serious issue where parties have entered into a transaction believing and understanding they were buying conservation districted property with all the burdens that come along with such property, and then for whatever reason, attempt to do something else. So for those reasons and the other reasons that were brought out in the questioning, I would ask that my motion to deny the petition would be granted. It, of course, does not preclude the petitioners from moving forward with their district boundary amendment, provided they meet the burden of proof on that petition. Thank you.
Okay. Commissioners Ohigashi, Chang, then Axon.
I'll be supporting the motion to deny, and one of the reasons why is I think that petitioner had to provide evidence that the Land Use Commission map H65 was erroneous or clearly done wrong, or that the interpretations that were done was clearly done incorrectly. And I'm not convinced that it was. Second thing is that I want to include in that is that an affirmative denial of petition to recover appropriate hearing costs and fees. I don't think that we have established any basis for that, nor is there any reason to believe that they should be entitled to such fees. I don't believe that there's been presented any evidence of that request. So if my understanding, if Mr. Okuda's motion would include that, I wouldn't have to make a separate amendment to them. That's all I have.
Commissioners Chang followed by Axon.
Thank you, Mr. Chair. I am going to be voting in favor of the motion for several reasons. One, I too am not convinced that there was a mistake made in the map. I believe both Office of Planning concurs that that there is no, while she's raised some other examples, there is no situation she is aware that is factually the same as this one. Three, in my view, based upon the church's testimony, and they have been extremely committed and they've done a lot of work, but this appears to be essentially a DBA. And if it was a DBA, there would be notice provided to all of other interested parties. And in my case, and in my view, the results of what they're asking is to change their property from conservation to agriculture, to me has potentially far-reaching effects farther, well beyond their own property. And none of the adjacent landowners have been given the opportunity, as would have been provided in a district boundary amendment. For the McCulleys, as well as the churches in the past, have relied upon the existing zoning as being conservation, and they've individually sought DBAs. So there's been a reliance on these previous landowners, including the church, that the property is conservation. And I also recognize, five, that a lot of this, and this is not the first case where there has been concerns regarding DLNRs, conservation land being too restrictive. But I think DLNR is acting appropriately because conservation district has a very different mission than agriculture. So if you're truly interested in doing agriculture, then I think a district boundary amendment is the much more appropriate action than to try to use this, than to take action in a declaratory action. So I will be voting in support of a motion to deny the request. And likewise, as Commissioner Ohigashi, if there is a friendly amendment to including the denial of the waiver of the petitioner's other requests for the waiver of fees, I'd have no objection to that. Thank you, Mr. Chair.
Thank you, Commissioner Chang. Commissioner Axon followed by Commissioner Okuda.
Thank you, Mr. Chair. I'll be voting in favor of the motion, but I'm just wondering, like Commissioner Chang mentioned, that if Commissioner Okuda would consider incorporating his motion, the denial or accepting the waiver of the fees
Commissioner
in one
Okuda.
motion.
Yes, this is Gary Okuda. I do agree to what Commissioner Axon is suggesting and the friendly amendment as described by Commissioner Chang and Ohigashi.
Okay, so you are saying the motion is to both deny all portions of the declaratory ruling sought by the churches, both regarding the boundary location as well as regarding fees.
That is correct.
Do you agree, Seconder Commissioner Cabral?
Yes, I will agree with that amendment to the motion. Thank you.
Commissioner Giovanni.
Can I say something?
Sorry, I apologize,
Finish my-
Commissioner Axon.
Sorry. Okay. Yeah. Thank you, Commissioner Okuda. You know, I can feel the uneasiness among the commissioners regarding this the petition. Me myself too is kind of uneasy or uncomfortable to the fact that it will set a dangerous precedent on many of the decisions made by the prior commissioners, and I'm not really convinced to the church petitioners' arguments, and I kind of go back to that the official LUC map, age 65, Papaico accurately reflects the Commission's intent in the 1969 boundary review for properties located along the Hilo to Kapoho coastline. So I'll be voting in favor of the motion, Mr. Chair.
Thank you very much, Commissioner Axon. Anything further? No, I don't want to cut you off. Commissioner Giovanni.
Thank you, Chair. I will also be joining my fellow commissioners who've already spoken in support of the motion as amended for many of the same reasons that have been given. I just want to add to that, however, that I was a resident of the beautiful Hamakua Coast for 5 years during the period when many of these parcels of land came up for sale. It was like a land rush, and there was a lot of confusion by the parties involved in terms of representations by realtors, in terms of interpretations that were bantied about. It was generally known to the residents of the area that there was uncertainty. And it seems to me personally that the churches entered into their real estate purchase with their eyes wide open, quote unquote, meaning they knew it was conservation land and districted as such. And they must have expected that there were some complications or burdens to fulfill their dream. They probably had no real appreciation for how burdensome or complicated it could be. Nonetheless, I am sympathetic to their efforts that having to gone through what they've gone through. But that's the reality of purchasing conservation districted land on the coast in Hawaii. So eyes wide open. It's unfortunate. I think that this matter, if they want to pursue it, is far more suited for a petition as a district boundary amendment. I will support the motion for denial. Thank you.
Thank you, Commissioner Giovanni. Commissioners, anything further? Commissioner Wong?
No, Chair. All the commissioners was eloquent enough. I'll just say I'm going to support the motion.
Seeing no further statements from the commissioners, I will add to my original comments. I'm going to vote in favor of the motion as well. I agree with Commissioner Okuda's statement regarding the applicable standard, that there has to be a preponderance of the evidence. And while Mr. Church and Ms. Hildahl have certainly laid out some very interesting points, I believe in his oral presentation towards the end of it, Mr. Church stated that he was forced to interpret based on the absence of certain information that this is what the commission had done in the past. That doesn't rise to the standard, I believe, that we need to follow in this case. And then the second reason, just to explain a little bit more, which came up during our deliberations, I'm actually fairly confident that if we ruled in favor in this case, we would end up in litigation. We would be dramatically affecting the location of the conservation district versus agricultural district boundary line along this section of coast. I believe there would be a rush of people who come to us seeking reinterpretations. There could be theoretically, well, people could potentially bring takings arguments against the commission based on former actions of the commission, were we to rule in favor of the church's motion. I'm not saying those would prevail, but the standard that we have to look at on DRs. Is there a likelihood of litigation? Knowing the County of Hawaii's sometimes very relaxed allowance of the building of homes and residences in the agricultural district, we could see this coastal portion of the state have a lot more residential use on it, which would go to the fundamental purposes that we are charged with protecting in our actions. That said, I'll just highlight, like, I am looking forward to, if the churches are so inclined, them bringing back their district boundary amendment petition. I don't know if they're on the 10-yard line or the 1-yard line on it, but I know that they are definitely like on the home half of the field and close to being able to bring that in front of us. So with that said, is there anything further? If not, Mr. Ordanker, will you please poll the commission?
Thank you, Mr. Chair. The motion is to deny the petition, including the request for waiver of fees. Commissioner Okuda,
Yes.
Commissioner Cabral,
Yes.
Commissioner Axon,
Aye.
Commissioner Giovanni,
Aye.
Commissioner Chang,
Aye.
Commissioner Ohigashi,
Aye.
Commissioner Wong,
Aye.
Chair Schroeder.
Aye.
Thank you, Mr. Chair. The motion passes with 8 votes unanimously.
Thank you very much. With that, it is 12:31. Our next agenda item is the Kihei High School matter, but we need to take a break for lunch. My indication is to go on the shorter side of things for 30 minutes. I know that might be too little for certain people, but I'd prefer to meet at 1:05 to take up the Kihei High School matter, which has considerable things. Commissioner Axon?
Just a reminder that I will have to leave by 2:30.
Thank you. And Commissioner Wong has to leave by 3, I believe.
Yes, Chair. Thank you.
Okay, we're going to go into recess and reconvene at 1:05 to take up the next agenda item. Oh, okay. Okay, we have Commissioners Okuda, Scheuer, Cabral, Axon, Giovanni, Ohigashi, Wong, Chang. Is Maui County back? Mr. Hopper? Mr. Hart is there. Mr. Hopper is there.
Here, Chair.
Okay. We have Ms. Kato. Okay. It is 1:06 p.m. We're back on the record. All I'm going to say at this point is that I have filed a voluntary recusal on the next agenda item regarding the Kihei High School. I'm going to read my recusal into the record, an email I sent to, among others, Vice Chair Giovanni on the 3rd. As you are aware, on August 19th, 2021, the State Department of Education filed a motion, quote, for recusal or disqualification of Land Use Commission Chair Jonathan Scheuer from participation in any proceedings related to the Department of Education's motion to amend the Land Use Commission's findings of fact, conclusions of law, and decisions and order filed July 29th, 2013. Because the motion was filed after the August 25th agenda for their main motion to amend was proposed, and hence this later motion was not able to be properly placed on the agenda, I deferred both of these matters at our August 25th, 2021 meeting. After thoughtful consideration, I have decided to recuse myself from any further deliberations on this petition and the motions associated with this petition. I do not agree with the petitioner DOE with regard to their assertions that my recusal or disqualification is required under the law. However, I do believe their motion for recusal or disqualification is itself a distraction. Because of this, I further believe my withdrawal from deliberations will eliminate the distraction and allow the remaining commissioners to focus on the substantive matters before the Land Use Commission, which most importantly is concerned with the safety of students and other pedestrians related to this docket. So from here, First Vice Chair Giovanni will chair the meeting and I will excuse myself. Mahalo nui.
Thank you, Chair Scheuer, for your careful consideration and thoughts. We will miss you. But we will proceed with the next agenda item. I am in the absence of a gavel, that Chair Scheuer has, so I will probably be making different noises along the way. The next matter is item A11794, Department of Education, Kihei High School, Maui, to consider petitioner's emergency motion for disqualification of LUC chair from participation in any proceeding related to DOE motion to amend the Land Use Commission findings of fact, conclusions of law, and decision and order filed July 29th. This motion is now rendered as moot due to the Chair Scheuer's voluntary recusal. We will therefore move on to the next agenda item relating to Kihei High School. We will now consider the petitioner Department of Education, Kihei High School motion to amend the LUC's finding of fact, conclusions of law, and decision and order that was filed July 29th, 2013. Can I ask that the parties please identify themselves in this petition, starting with the petitioner?
Good afternoon. My name is Stuart Fujioka. I'm a Deputy Attorney General appearing on behalf of the petitioners.
Is there anybody with you, or are you just the sole representative for DOE?
On the panel, it's just me. There are two deputies listening from my office listening in, and I do have, let's see. Yeah, I'm hoping that Randall Tanaka will be joining us. He's been in and out.
Okay, thank you. From OPSD?
Allison Kato, Deputy Attorney General for the Office of Planning and Sustainable Development. Also here are Ronnie Funakoshi, Nuri Makia, and Mary Alice Evans from OPSD. Thank you.
Thank you. County Maui?
Thank you, Vice Chair. Michael Hopper, Deputy Corporation Counsel, representing the Maui County Department of Planning. With me is Deputy Planning Director Jordan Hart.
Thank you. Okay, before we begin, I'd like to update the record. On November 2nd, 2020, the Commission received petitioner's update regarding the motion to amend the Land Use Commission's finding of fact, conclusions of law, decision order filed July 29th, 2013, and exhibits 10 through 18, and the accompanying certificate of service. From November 2nd to 4th, the Commissioner received testimony from Andrew Beer, Mike Moran, Libby and Terry Fulton, Patricia Stillwell, Representative Tina Wildberger. On November 4th, 2020, the Commission met via Zoom virtual conferencing to hear this matter. Commissioner, on November 10th, the Commission mailed LUC questions for DOE and DOT. On February 1st, 2021, the petitioner filed its response to LUC's letter dated November 10th, 2020, with respect to the petitioner's motion to amend the LUC's finding of fact, conclusions of law, and decision and order filed July 29th, 2013, exhibits 19 to 30. On May 4th, 2021, the Commission received petitioner's request for hearing in reference to the motion to amend. On July 29th, the petitioner filed its request for the issuance of written findings on its August 20, 2020 motion to amend the Land Use Commission's findings of fact, etc., and a declaration of Stuart Fujinoka and exhibits 31 to 37. On August 2nd, 2021, the Commission received DOE's 2021 annual report from the petitioner. On August 12th, 2021, LUC emailed and mailed out LUC's meeting agenda for the August 25th, 2021 meeting to the parties in this docket and to the statewide and county lists. On August 17th, 2021, OPSD filed its response to the petitioner's requests and for the issuance of written findings. Also on that day, the commission received public testimony from Michelle Muir-White. On August 19th, 2021, the commissioner received DOE's emergency motion for recusal or disqualification of LUC's chair. On August 24th, the commission received Maui County's petition of statement as to the DOE's request for issuance of its written findings of fact. On August 25th, 2021, the commission met via Zoom to hear this matter, but due to the emergency motion filed by the petitioner, decided to defer this matter for today to properly agendize it. On August 31st, 2021, the petitioner filed supplemental exhibits to its motion, exhibits 38, 39, 40, 41, and 42. Between August 17th and September 7th, that's yesterday, the commission has received 327 public written testimonies in this petition. Those will not be identified, but they are posted on our website due to the lengthy amount of them. On September 1st, 2021, LEC mailed and emailed an agenda for the September 8th and 9th meetings to the parties in this docket and the statewide and county lists. On September 3rd, 2021, the commission received testimony from the Wailea Community Association. Also on that day, the commission received OPSD's response to the DOE's emergency motion for recusal. On September 3rd, 2021, the commission received an email communication from Chair Jonathan Scheuer, formally recusing himself from further participation in this matter. And this morning, Chair Scheuer voluntarily recused himself from the proceedings. We also had two late filings of public testimony that were also posted, received yesterday. One were exhibits 43 to 44 from the petitioner and their certificates of service, both of which have been posted. So let me run over our procedure for this docket. First, I will recognize any written public testimony that has been submitted in this matter. Next, I will call on individuals who want to provide public testimony in this docket. All such individuals will identify themselves using their raised hand webinar function on their device screens or by pressing *9 if accessing by telephone. Let me say that I do not have the same functionality and visibility as Chair Scheuer did from his location, so I will be relying on Mr. Derrickson, who is a member of the LUC staff, to work with me online to recognize and call into the Zoom room for testimony, for public testimony for those. So it may be a little bit cumbersome compared to what you've been used to, but we're going to have to work through that. But once you get in there, you'll be called up into our virtual witness box. You'll be able to, and will be asked to turn on your audio and video and will be sworn in by me. You'll be asked to keep your testimony to 2 minutes each and will also remain available after the testimony to respond to any questions the parties or commissioners may have. When all questions have been completed, I will excuse the witness and put them back into the viewing audience. Again, I will ask Mr. Derrickson to assist me in doing this maneuver, and we will call the next witness to enter the virtual witness box. The commission will then begin proceeding on the motion to amend, starting with the petitioner's presentation, following by questions and answers from the commissioners. Next, the County of Maui Planning Department will make its presentations and receive questions. Finally, I will call on the state's Office of Planning and Sustainable Development to make its presentations and receive questions and comments. Petitioner will then be given the opportunity to provide any rebuttal it wishes to put on the record. The commission will then hear the request of the issuance of written findings. Finally, after all parties have presented their arguments on the petitioner's motion to amend and the request for the issuance of written findings, the Commission will conduct deliberations and issue a decision on this motion. I will also note for the parties and the public, and from time to time, I will be calling for short breaks of approximately 10 minutes. Let me note that the intent as of this time is that due to having two members of the commission, two commissioners will be leaving, one at 2:30 today and one at 3 o'clock. I intend to adjourn this meeting at 3 o'clock today, and therefore will only plan to call one 10-minute recess at approximately 2 o'clock. Are there any questions with our procedures today on the matter? First from the petitioner.
I don't have a question on the procedure, but I did want to say that when the filings were being recited, there was one that was made early this morning. We submitted an exhibit 45. I think the list only went up to 44.
Yeah, I will be asking next to the staff, LUC staff, about any late filing. So we'll catch that at the time.
Okay, thank you. Other than that, nothing on the procedure.
Thank you. County?
No, Chair, and or no Vice Chair. We also had a late filing, so hopefully that would be addressed in the same manner. Thank you.
Thank you. OPSD?
No questions, thanks.
Okay, so now, Mr. Hakoda, have there been any written testimony submitted on this matter or any late filings?
Yes, Mr. Vice Chair, as Mr. Fujioka mentioned, there were two late filings. One as late as this morning, about 8:30, with the exhibit 45, and the early one that you mentioned in your recap of the record. County of Maui also submitted a supplemental update to their position statement with a couple of exhibits that Commissioner Okuda had requested in regards to the pedestrian separation from traffic and pedestrian crosswalks.
Okay, thank you for that clarification. So now we'll proceed to public testimony. Mr. Derrickson, are you ready to work with me on this?
I am.
So let me first, I know we've had a request from somebody who has to leave early. Would it be possible to bring Miss, I believe it's, let me just double check. Yeah. I think Kelly is in the waiting room. Do you see Kelly in the waiting room?
Kelly King?
Kelly King, yes.
Yes.
We, since she has to leave early for another matter, I would like to move forward and bring her in first.
Okay, so I'll bring in Kelly King first with Mike Moran on Dept.
Okay.
Hello, Kelly.
Commissioners.
Could you please say your name and address for the record, and may I swear you in?
Okay, my name is Kelly Takaya King. I live at 72 Kalola Place, Kihei, Hawaii, 96753.
Do you swear or affirm the testimony that you're about to give will be the truth?
I do.
Please proceed. You have 2 minutes.
Okay, thank you so much, Commissioner Giovanni. I'm really happy to be here. I had submitted written testimony yesterday, so I stand on that testimony, but I want to impress that I'm speaking as a longtime Kihei resident, 40 years as a council member for the South Maui District, as a former Board of Education representative for Maui District, and most importantly, as a parent who's raised 2 children in Kihei who are now out of college. I thought a long time ago when I joined the group that was working for this high school that was trying to get the Kihei High School built, that my kids would actually be able to go there, but that has long passed. But I still have concerns for my community and the safety of our students and our children. And as you've seen in my written testimony, The underpass is vitally important for this community. You'll hear a lot of other testimony in regards to the report that was done for the South Maui community in connection with pedestrian and bicycle paths called the Safe Routes to Kihei High School, Pedestrian Route Safety Study in 2014. And you'll note in that study that it recommends Waipuilani Gulch as the best site for the underpass. And the reasons I'm sure will come up in other people's testimonies. I want to talk about safe routes and pedestrian safety because our council just passed a resolution recognizing August 2021 as Pedestrian Safety Month. And I have to tell you, it makes me really sad that the Department of Education is setting aside the safety of our students and our high school children in this area, asking them to walk across the 4-lane highway to get to school. But the safety is the primary component of Maui's Vision Zero Maui Action Plan. And to me, this does not fit in with the Vision Zero. We've already had, just in the recent couple of years, one young lady who was killed in an auto accident on that highway in that same area. Another goal of our vision plan is to institutionalize Vision Zero. That requires agencies, organizations, and jurisdictions across Maui to collaborate and build a broad coalition of support for Vision Zero so that our principles can be embedded in the planning, design, prioritization, funding, and implementation. And then lastly, I didn't have this in my testimony, but I wanted to point out, as others may as well, that our Kihei McKenna community plan actually states, upon adoption of this plan, allow no further development unless infrastructure, public facilities, and services needed to service new development are available prior to or concurrent with the impacts of new development. And under the physical and social infrastructure goal, allow no development for which infrastructure may not be available concurrent with the development's impacts. The crossing of the highway is a huge impact. And I think the community, from the people I've talked to, there's nobody who has said, we're so ready to open this school that we're willing to let our children cross that crowded highway and that dangerous intersection, and on a highway that was meant to expedite traffic as well. So I hope you pay attention to what we have as a community decided, and we are in the review period right now, but right now this is the language from our existing community plan. So thank you very much for the opportunity to testify in opposition to the petition being proposed today. And I'm ready to answer any questions if you have them. Thank you.
Thank you, Ms. King. Petitioner, do you have any questions for Ms. King?
No, thank you.
County, any questions?
No, Chair, thank you.
And OPSD, any questions?
No questions, thank you.
Thank you, Ms. King. Commissioners, any questions for Ms. King? Commissioner Okuda.
Thank you very much, Mr. Chair. Councilmember King, I'm going to ask you a question about Exhibit 6, which was attached to the petitioner's motion to amend the Land Use Commission's findings of fact, etc. In that Exhibit 6, which was a resolution number, I believe, 19-20, adopted by the Council of the County of Maui on February 1, 2019. Let me read a very short sentence from that resolution, and I'm going to ask you whether or not what I read accurately reflected the representations made by the state of Hawaii to the Maui County Council. And this is my quotation reading from the resolution. Quote, whereas during a public meeting on the proposed change in zoning bill that became Ordinance 4135 on October 30, 2013, the Council's Land Use Committee received assurances from representatives of the state that an overpass or underpass would be provided pursuant to the Land Use Commission's conditions. Is that your recollection of what took place at the Council Land Use Committee's meeting, to the best of your knowledge?
Yes, thank you, Commissioner Okuda. To the best of my knowledge, that is exactly what took place, that we were assuming at that point that they were following through with the underpass or overpass.
Would it be fair to say, or you tell me, did the County Council of Maui rely on those representations or assurances as described in resolution number 19-20, the representations or assurances that were made by the state?
Yes, I believe so. That is why we passed that resolution unanimously. I can't say for sure what was going through each council member's minds, but that was part of the discussion, as I recall.
When the term state is used, do you have a recollection with more specificity of what that refers to? Is that the Department of Transportation, Department of Education, or your best recollection is it's just somebody from the state?
Well, my recollection is, and the way that we talk about the state is the state administration encompasses the Department of Education and the Department of Transportation. So when we talk about the state, it's usually as a broad term, it's the administration.
Did anyone from the state, as that term is used in the resolution, did anyone from the state come back to the county council and tell the county council that the state intended to modify, take back, abrogate, or do anything different from the assurances that were given to the Maui County Council?
No, in my recollection, there was nobody who made that statement from the state.
Okay, thank you very much, Councilmember King. Really appreciate the clarification. Thank you, Mr. Vice Chair. No further questions.
Thank you. Commissioner Wong, do you have questions for our witness?
Yes, Chair, thank you. Thank you, Council Member. A couple questions. First off, if I remember correctly that the County of Maui still has to do a certificate of occupancy.
Correct.
So the DOE cannot move in pretty much and start school until certificate of occupancy is given by the county, correct?
Correct.
So does the other thing, please explain this one to me. Can the council do anything in its wherewithal to stop that certificate of occupancy, or say you cannot do anything else until you do something?
Well, yeah, thank you for that question. That's kind of a tricky issue because, the council members are not allowed by our charter to direct administrative employees, but we can set policy. And in my estimation, the request that's being made of you today is a violation of the community plan, the Kihei McKenna community plan, as I read those sections to you. So normally when somebody wants to do something that's outside of the community plan, they would come to the council for a community plan amendment. And we have not had that happen yet. So, one of the actions the council could take is to ask court counsel for a legal opinion on whether a community plan amendment would be required. And if that's the case, then it would be a council action before the certificate of occupancy could be issued.
So this is just hypothetical.
Yeah, mine is hypothetical too, because I don't know what the outcome of that court counsel opinion would be, but I would be prepared to ask for it.
Just because I'm just thinking hypothetically that, let's say, you go down that route. Council does go down that route to ask court counsel. So you pretty much could stop DOE from moving in at that point in time, correct?
Correct.
Okay. No, I just wanted to know these things just because, I want to know what is the line of where council can go and where administrations can go.
Yeah, I appreciate that question so much. I would hope that I had hoped that we would be working together. The Kihei High School is so important to our community, and as a parent of former high school students, I would love to see that school open, but not at the expense of even one life. So, I really appreciate your discussion, because there are things, that we are going to have to think about if we don't get the ruling that we need today.
Yeah. Thank you, Council Member. I just, like a father also, and uncle, and uncle here, that I also think the same way. But thank you again.
Thank you,
Chair.
Thank you. Commissioners, anybody else? Commissioner Okuda, you have a follow-up question for Councilmember King? Put your hand down, then, I guess. Thank you. Seeing no further questions, Councilmember King, thank you for taking the time today to testify.
Okay, thank you. And thank you to all your commissioners for all your good work. I sat through the first issue and I really appreciated all your comments and questioning.
Thank you.
Aloha.
Aloha. Mr. Derrickson, who is our next public witness?
Next public witness is Mike Moran.
Will you invite him to the virtual room, please?
Yep, it's in process.
Next up.
Who's on deck?
Next up on deck is Buck Joyner.
Thank you. Mr. Moran, please put on your video and your audio.
Aloha, commissioners. My name is Mike Moran. I live at 167 Aha Way in Kihei, and I am testifying as president of the Kihei Community Association for the commission, and I swear to tell the truth.
Okay, well, you took the words out of my mouth, so please proceed. You've got 2 minutes.
Thank you, sir. Appreciate Vice Chair Giovanni for your stepping in here, and please excuse me, I'll be peeking down to, I'm going to try and squeeze this into 2 minutes. Mahalo for your volunteer public service, especially those commissioners who recently re-upped. It seems like deja vu all over again, as while none of you were there in 2013 when this original condition was approved, as we were that day, you have been involved numerous times, such as your site visit over 3 years ago, and more recently, the declaratory ruling in 2019, and then a deferral in 2020. But I would mention that part of that deferral, the DOE did not reach out to the community after that decision. And we asked a rhetorical question, are they obligated to explain when they simply disregard what is stated by this commission? So we ask, has anything changed since the prior meetings? Is there any valid reason to make a change after about 8 years? You have heard a plethora of excuses like misunderstanding the meaning of the condition. Is reading comprehension a requirement of this department named education? Our prime concern remains safety of the children, but also our entire community who will visit the school facilities days and evenings, school days and weekends. And the condition placed by this commission on the DOE back in 2013 remains sound. Please keep the pedestrians off the highway. But for those who seem to disregard pedestrians and their safety, perhaps have more concern for motor vehicles, we offer this. Every time any pedestrian walks across the highway, all traffic stops. Currently, it is unsafe to walk or cycle along this highway, and the state has no plans to alter that situation. Rather, the intent is to make it even worse by now having the multimodal function now go across this highway as well. So we ask you to please continue to keep the condition in place and safeguard our community. Mahalo for the opportunity to testify.
Thank you, Mr. Moran. Petitioner, do you have any questions for Mr. Moran?
I'm sorry, I was muted. I do have a few questions, Mr. Vice Chair. Mr. Moran, are you familiar with the Kihei Community Association's website?
Yes, sir, I am.
I'd like to show you a couple of screenshots and ask if you can identify them or verify them.
So are these exhibits that are in the record, Mr.
Yes, Mr. Moran, I'm going to show you Petitioner's Exhibit 43 first. Can you see it?
Yes, sir.
You recognize this as a, I guess, a invitation or advertisement for sign waiving to be held August 19 of this year?
I don't see any, I'm looking at the part that's highlighted. I don't see anything about sign waving on there. Is that what you're referring to?
Do you see a screenshot of something that appeared? Oh,
Showing prologue.
sorry, something else is on the screen. You're right. Okay. Right, because do you see a screenshot now?
We see
Yes, I
your,
see a screenshot, but it's got several different, very
no,
tiny items on it.
I'm sorry, this is, my computer is not, this is not showing what I had wanted you to see.
It's only showing that window.
Oh.
See exactly that screen.
Okay.
See exactly that screen, so double click on that exhibit. No, that's what he's doing. That's
Yeah.
not, it's not pulling up. I think you have to go back to the share screen. Wait, okay. Click the share screen again. Wait, and linger. Should be fine.
Okay. No.
Is it not open though? Maybe you need to open it so it shows up on here.
It was.
Go back to the file, double click it and open it.
Mr. Fujioka.
Minimize it. Yeah. Okay, let's go back to that screen. Sorry, one more time.
Last time, or then we'll proceed.
Okay. If I could try this one more time.
Oh, it's not pulling up.
No, I don't see it. Something.
Mr. Fujioka, may I
Yes.
suggest that you fix this problem on your own time?
Yes, I will.
And then present it as part of your testimony.
Okay, I can do that.
Thank you. Any further questions for Mr. Moran?
Just that there was a sign waiving held on August 19 of this year, correct?
That's correct, sir.
Yeah, were you there?
Yeah, I was.
Okay, that's all I have. Thank you.
Thank you. County, any questions for Mr. Moran?
Oh, no, thank you, Chair.
Thank you. OP, any questions for Mr. Moran?
No questions, thank you.
Thank you. Commissioners, any questions for Mr. Moran? Seeing, oh, wait, Commissioner Chang, I see your, yeah, it helps me with my little screen if you could also kind of do that.
Yeah,
So,
I'm sorry, I'll wave.
okay, Commissioner Chang.
And my hand is nice and brown. It's not yellow, so it's a little difficult to see. Thank you, Chair. Mr. Moran, thank you so much. I've greatly appreciated the Kihei community's diligence and commitment in this, and yours has become a familiar face. So thank you for being here again. Greatly appreciated. So Mr. Moran, I'd like to ask you, currently it is Kihei Communities Association's position. They are opposing the Department of Education's motion to amend the condition 1B. As I read through your testimony dated August 10th, 2021, the KCA is requesting that LUC mandate the DOE to provide an updated and accurate GSPC feasibility study and updated traffic studies as required by LUC conditions 1A and 1B. Is that correct?
That is correct, Commissioner.
And and if those studies, if LUC requires that these studies be updated, is the community, and I'm going to ask the same question of DOE and DOT, is the community going to accept the results of those studies? You know, no matter what, if it says an underpass is not acceptable, will you accept that?
I have to, in my position, Commissioner, I have to try and speak for the community. So, you know, I would have to go back to the community after it happened and try and get the input. But if it was today, it's like, what does the community think? My expectation is the community would say, no, we're not going to accept anything but safe passage. I base that on some of the past meetings when I felt the most affected people. We had, I believe it was the 2019 meeting, when we had several potential parents come to the commission and state that we would rather delay our child going to the new school rather than have unsafe passage across this highway. We would rather send our children into Maui High by bus or whatever, rather than unsafe passage. And we tried to, the last couple of days, we tried to look at that 300 and some written testimonies, and we certainly didn't get through all of them. I would guess scanning wildly through, I might have gotten to 100. And in those, we did not see one testifier saying anything but they wanted preferably the underpass, but they wanted the condition kept in place. So based on that, I would have to assume, and I'm assuming because I would have to get it from the community, that no, the community is holding strong. We want nothing but safe passage.
I appreciate your candor on that. I'll share with you, and you know, we're only at the beginning of the proceeding, but to a certain extent, we have to rely upon expert testimony. And I understand parents' fear. I am a parent and I have grandchildren as well. Totally understand and appreciate that. But if there is expert testimony saying that one, the underpass or the overpass, or the safest is this roundabout, or the underpass or overpass is not safe. Well, let me ask you this question. What is the community relying on to say that it's not safe? I mean, that the roundabout is not safe and that the only thing that will be safe is the overpass or underpass?
To clarify, Commissioner, I would offer, going back to 2013, KCA has for years advocated for a roundabout in place of a crossroad. We have had, I mean, we're an unfunded volunteer group, but we even paid almost $1,000, which is a lot of money to us, to get professional input on the advantages of a roundabout over a cross section. And overwhelmingly, all experts from the federal government down indicate that a roundabout is safer for all modes of transportation. It's safer for the pedestrians, it's safer for the bicyclists, it's safer for the people in the vehicles. So we have advocated for a roundabout. Back in those days, the Department of Transportation for Hawaii opposed the roundabout. They were completely opposed it. They said, we've never done it. We're not going to do it. And we continue to persevere. Now, as you probably know, the Department of Transportation has completely reversed that position and is now taking the position that the federal government does, that most states do, that many countries around the world do, saying a roundabout is safer for everyone. And the concept is that the vehicles must drive, they're physically forced to drive slower. So the concept is, okay, well, that will make any collisions, and we say they're not accidents, they're collisions, any collisions less severe. because any engineer will tell you that the slower the vehicle is moving, the less damage it will do, the more chance there is to avert the collision by people getting out of the way. So when we hear expert testimony, sometimes the expert testimony changes over the years. And there's many experts who have given input on this, saying that the underpass is the safest choice. The grade separated crossing, either over or under, is certainly safer than going across the highway. And the more practical way, because it would be used more, is to do a underpass. So we've relied on expert testimony, and we see how the State Department of Transportation changed their position on roundabout, but they don't seem to be changing their position. And they're kind of the exception to the rule from all the so-called expert testimony that we have seen, and we've submitted a lot of it. We've had several meetings over the years with different people, and we have presented examples of what are generally referred to as river walks, where there's a stream, even though our stream is dry 9/10 of the time. We get it that sometimes it would flood, but if you
Mr.
have,
Moran,
I'm sorry, I'm going on too long. Commissioner. Go ahead.
I'm sorry to interject, because I know that we've got kind of a short time period, so I just want, because there is an agreement on the roundabout, and I guess the question that I'm facing, the issue that I'm facing right now is there's a condition that before the school can open, that these things have to occur. And you seem to say that many parents and community members that you've spoken to have said, we're willing to say, and I just heard from Mrs. King, that we're willing to say, we'd rather not open the school at all if it means we don't get the underpass or the overpass. So I'm wondering, is the community willing to accept sort of this phased approach of doing the roundabout first, open the school, phase 1, continue the studies, get an updated TIRA, GSPC before we move into phase 2, which may or may not include the overpass or the underpass, but as a compromise, and I believe the county's raised it. So has the community talked about that, and is the community willing to accept that phased approach?
Well, our understanding, Commissioner, from hearing the Department of Transportation spokesperson last month said that the roundabout would start construction next month. Now, October, it would be finished in July. No questions asked. The roundabout is a go. That's what we heard the Department of Transportation state publicly. So that doesn't seem to be part of the equation. They're going to do it before the Department of Education has forecast when the school is going to be open. We do have some questions about when the Department of Education says the school is going to be open, because we go back to 2016 when they told us the school was going to be open. So we always have reservations on these predictions when it will be, but our understanding is the earliest the DOE says the school would be open would be August of next year. The DOT says the roundabout will be completed. So that part seems to be a done deal on the DOT's part. But our community is saying having a roundabout which will slow the vehicles down is still not, we don't want to make a compromise that it's okay for a child crossing the highway to get hit by a car going 20 miles an hour as opposed to a car going 50 miles an hour.
Moran, let me stop you there. I don't think
Yes, sir.
we appreciate the energy that you have behind your position, but you need to listen to the questions and answer them specifically.
Thank you.
And let me encourage you, when you're asked a yes or no question, try to answer it yes or no.
Will
And
do.
I think the question was, would you agree, yes or no, to a phased approach where the school is opened with only a roundabout, and then some future time there would be a study that may go up or down on a overpass or underpass? Yes or no? Would you agree with that phased approach? Is that a correct statement of your question?
Yes, it is. Thank you. Thank you, Commissioner Giovanni. Yes.
Today's answer would be no, sir.
Thank you, sir.
All right. Thank you. No further questions, Commissioner Giovanni. And thank you, Mr. Moran.
Commissioner Okuda?
Thank you, Mr. Vice Chair. Mr. Moran, with respect to the Waipulani Gulch, do pedestrians today go and walk underneath the highway bridge at the Waipulani Gulch area? In other words, are people using that underpass as a method of getting from one side of the highway to the other side? Is that happening now?
It is certainly happening. I have personally seen it dozens and dozens and dozens of times. I ride a.
Okay, that's
I'm sorry. Yes. Thank you.
Okay, then let me ask a question which may or may not be related, shifting gears slightly to what Mr. Fujioka was asking. If you had, or since you had all these picketers or sign waivers, let's not call them picketers, sign waivers on the highway, how would you respond to an observation saying KCA is just exaggerating the danger of the highway because you all not only invited people to come out and sign wave, you actually went out there and sign wave. So you're overstating the danger of the highway. What is your response if that was the question or comment?
To be clear, Chair, we were not on the highway. We were not even on the shoulder of the highway. We were, I'm going to guess, minimal 20 feet, 30 feet away from the shoulder on a plot of land. The land juts out there before the gulch. And we did have one exuberant sign waiver who did walk out onto the bridge, and the rest of us were saying, "Get off there! What are you, crazy? That's not what we're doing." But you know, no, we were not out there, our group.
Okay, thank you very much. I just needed clarification of that. Thank you, Mr. Vice Chair. No further questions.
Thank you, Commissioner Okuda. Any other commissioner have a question for Mr. Moran? Thank you, Mr. Moran. You're excused.
Oh, mahalo.
So it's 1:56. I want to take a short break at this time. We will resume at 2:03. Here's my gavel. Michael Hopper, are you there? County of Maui?
Chair, you also may want to check for our AG.
Where is she? Julie Chena, are you there?
Yes, I am.
Thank you. Just waiting for Mr. Hopper.
Chair, before you get on the record, Ms. Kato is raising her hand, so just FYI.
Ms. Kato, do you have something to?
Right here, Chair.
Thank you, Mr. Hopper. Okay, we're back on the record. It's 2:04. Let me just encourage everyone, this is a Zoom meeting, so we are going to try to Zoom. The intent is to adjourn today at 3. We have 6 additional testifiers in the waiting room, which will require us to go through expeditiously if we're going to meet our target adjournment time. And I really encourage everybody to listen to the questions, and if they're simple yes or no questions, please answer with a simple yes or no if you can. So, Ms. Kato, did you have a comment?
Oh, sorry, it was just to ask if we had an estimated time, but you just gave an estimated time. Thank you.
Very well. Mr. Derrickson, next up for testifying.
Next up is Buck Joyner.
On deck.
And on deck is Madeline Wells.
Okay. Mr. Joyner will be coming in. When you do, Mr. Joyner, please start your video and your audio.
Right there.
Will
Why
you
is
have-
my camera not working?
Okay, we'll just go with your audio. We do hear you fine.
I don't understand why the camera isn't working. I will give oral testimony and
Yes.
extreme apologies, and try to share screen if that is possible.
You can't give video, you can't share the screen. It's audio only.
No, crap.
So,
Hang on, I'm not good at this. There we are. Okay, so I'm Buck Joyner from Kihei.
What's your address, please?
And I will be telling the truth. 3443 Malina Place, Kihei.
Do you affirm the testimony you are about to give will be the truth?
Absolutely, yes.
Mr. Joyner, you have 2 minutes.
Thank you. I am a 40-year Maui resident, formerly on the board of directors of the Kihei Community Association. I was chairman of that traffic safety committee for 12 years. I was also chairman of the Maui County Traffic Safety Council. I have been a member of several state highway traffic groups. I'm a retired professional engineer. There is no consensus right now on the best solution for students crossing Pi'ilani Highway. I agree with DOT and DOE, hereafter abbreviated as DOTI, that a gargantuan overpass or a tunnel under Pi'ilani Highway would be grossly expensive and seldom used. Is my graphic showing?
No.
Okay, and my camera isn't working either.
Please make your remarks the best you can.
In my written testimony, I provided a map showing that approximately 85% of the students live either north or south of the 2 bridges that abut the high school property. And those children have to walk across the bridge and that bridge is 3 feet wide. The bridges are approximately 100 feet long. I severely, I'm frustrated. Is my screen showing now?
It is.
Okay, I'm just gonna have to go.
You're at 2 minutes now, so you can please summarize.
85% of the students live on either side of the bridges. And to pass those, to get to the school, they have to cross this bridge. And that picture is not showing.
I'm sorry, Mr. Joyner, you're going to have to.
Your apologies. The bridge is only 3 feet wide, the walk path. 100 feet long, cars screaming past, hundreds of kids, hundreds of cars. It's absolutely unacceptable. The DOT, DOE have said that the students may not cross through the gully. Therefore, they have to go over the bridge. So there is a solution, and that is to build a walkway across the bridge, across the gully, the gulches. That will allow 85% of the students to go through that walkway and then pass under the bridge. And we need 2 pathways and 2 underpasses. If my graphic is showing, you can see that the population density is about equal. The Gulf is high 99% of the time, 99.99. And
please conclude.
If flooding is a concern, the walkway could be on pontoons, okay? And that would eliminate the problem of the water. Okay.
Thank you.
I think I will pause there.
Yeah, so petitioner, do you have any questions for Mr. Joyner?
No questions, thank you.
Mr. Hopper, does county have any questions for Mr. Joyner?
No questions.
Ms. Cato, do you have any questions for Mr. Joyner?
No questions, thank you.
Thank you. Commissioners, any questions for Mr. Joyner?
My
Seeing
share
none,
screen worked last night in a test run.
seeing none, thank you, Mr. Joyner, for joining us today. We did see your screen. So we will excuse you now. Mr. Derrickson, could you bring our next witness?
Next witness is Madeline Wells, followed by Louise Lambert.
Thank you. Ms. Wells, please activate your video and your audio if you can.
Got it?
Great.
Whoops.
You have,
Wait,
please.
okay, okay,
We-
okay.
We hear you. Do you affirm the testimony you're about to give will be the truth?
Yes,
Please give us your full name and address, and then
Okay.
give us a couple minutes of testimony.
okay. Madeline Wells, I live at 168 Oluwea Circle in Kihei, you know what I mean, in Kihei, sorry. And okay, so I got to run through all this stuff. Aloha Land Use Commission. I'm testifying to urge the commission to deny DOE's petition to change the above or below grade requirements for students to cross Pi'ilani Highway to the new high school. I live off Kalani Hakoi, directly across the highway from the new school. Although this subdivision where I live is in a sheltered enclosure, the highway noise sounds like we are living just below a major freeway. During the years prior to this new traffic light installation 3 weeks ago, I would be stuck for many minutes waiting to make my left turn off the highway onto Kalani Hakoi. Once I noticed in real time how long the wait was when I heard how many songs played on Pandora. It was almost 4 whole songs. Since most are in the 4 to 5 minute range, it's easy enough to do the math, but not easy getting across. Not easy for students either, which is why charter school kids have to be driven no matter how close they live, if it's Mackay of the highway. My car is heavy and built close to the ground. Even so, it gets jostled alarmingly in the high winds caused from air currents moved by multiple vehicles, racing more than 20 miles above the speed limit. This is a windy part of the island, but during the shutdown last year, it was amazing how still the air seemed by comparison. Until I can get safely wedged into the left turnoff section, other cars close in behind me, pressuring me to speed. Many travel at terrifying velocity. Posted speeds in this area are 30 or 35. Most cars in the left lane are going between 50 and 65, but plenty at 70 and above. All it would take is a split-second attention lapse of an oncoming driver for me to get knocked across the road and cause a multiple wreck in both directions. But I would be inside my car. Imagine what it would do to a child on foot or skateboard, or several adolescents walking together. They are under pressure to get to class on time, or to practice, or rehearsal, or meetings. When 2 minutes can make the difference in a lowered grade or some form of demerit, it's easy to see how some might be tempted to run across against the stoplight. A walkway.
Please summarize if you can.
Okay, okay, a walkway under the Waipuilani and Kalani Hakoi bridges would provide access Mauka and Makai to high school students and charter school students up the hill on the Pua. Engineering information responses, Buck provided that. I guess hopefully you all will have a chance to see it later. Anyway, that's the only practical solution. It will cost almost nothing. It could be finished within about 3 weeks. And that could happen way before this roundabout would be done. This is a really dangerous stretch of road, and despite police issuing tickets up and down the highway, the speeding is heavy. Community members yeah, there's no way this could happen without sacrifice Keiki lives.
Thank you.
It's in the, okay.
Thank you very much.
Thanks for your consideration.
Thank you. Petitioner, questions for Ms. Wells? Mr. Fujioka, any questions for Ms. Wells?
I'm sorry, no questions. Thank you.
Thank you. Mr. Hopper, any
No
questions? Thank you. Ms. Kato?
No questions, thank you.
Thank you. Commissioners, any questions for Ms. Wells? Thank you, Ms. Wells, for joining us today. You'll be excused now. Thank you.
Thank you.
Mr. Derrickson, who's next?
Louise Lambert. Nick
Thank you.
Drance on deck.
Who's on deck?
Nick Drance.
Okay, thank you. Aloha, Ms. Lambert. Can you hear us?
Aloha, yes. Can you hear me?
Yes, we hear you and we see you. Do you
Oh,
affirm?
thank you.
Do you affirm?
My
that-
name is Louise Lambert. I live at 3265 Kehala Drive in Kihei, 96753.
Do you affirm that your testimony that you're about to give is the truth?
Yes,
Please proceed for 2 minutes.
thank you. Thank you. Thank everybody for their support in this matter. I'm a grandparent, parent, of course, but a grandparent, and have a 10-year-old grandson who will likely be going to the school. I'm a former teacher at Montessori Haleokeke, which was in that neighborhood where the school entrance is. There are dangerous sidewalks at the Kulani Hakoi and Waipuilani bridges, which Buck has in his pictures that hopefully you all have access to. So hundreds of students will need to walk, bike, or skate to school who live closer than the 1.5 miles from school that are ineligible for a school bus ride. And if we're depending on car rides for all these hundreds of children, it's definitely going to create more traffic challenges. So if we expect a large body of students to only cross at one place, it's not practical. Students will be coming from north of Kalani Hakoi and south of Waipuilani. And either we need to widen the bridges or create safe walkways, bike paths above, below, or beside the bridges to provide safe access for the students and all the people coming and going from school. With a 3-foot wide bridges with the cement 3 foot from the edge of the road for large groups of youth and fast moving traffic and cyclists and skateboards and whatever other means of transportation youth will use to get to school. We've got scenes set for fatal injuries. Thank you for paying attention to the very important safety of our youth. I believe underpasses are necessary for students traveling to and from school. And so I strongly advocate not waiving the requirement. Thank you very much.
Thank you, Ms. Lambert. You hit 2 minutes on the button and I'm so proud of you for doing so. Thank you. So petitioner, do you have any questions for Ms. Lambert?
No questions.
Mr. Hopper from the county, any questions?
No questions, Chair.
Thank you. Ms. Kato from OPSD, any questions?
Questions, thank you.
Thank you. Commissioners, any questions? Seeing none, thank you, Ms. Lambert. You're excused.
Thank you.
Mr. Derrickson, who's next? Who's on deck?
Nick Drance next, and Andrew Beer on deck.
Mr. Drance, please activate your audio and visual.
There we go.
There you go.
All
We
right.
hear you fine. Do you affirm that the testimony you're about to give is the truth?
I do.
Thank you. Can you please state your name and your address for the record and proceed with your 2 minute of testimony?
Nick Drance, 2441 South Kihei Road. Kihei, that was my assistant, and I will tell the truth. In the interest of saving time, just let me reaffirm the testimony from the prior speakers. And there's a tremendous number of people on social media, next door neighbor Kihei and Facebook, who are voicing similar opinions about that others have expressed here. A few of them dropped off because they were ready to sign up this morning at 9. So this is a big topic with the public here. And I think if a requirement is made, requirements are made for a reason, and we should leave it be and not accept the petitioner's request. And I thank you.
Thank you, Mr. Drance. You just broke the record. Thank you. 1 minute. So questions, Mr. Fujioka from the petitioner.
No questions, thank you.
Thank you. Mr. Hopper.
No questions, Chair.
Thank you. Ms. Kato.
No questions, thank you.
Thank you. Commissioners. See none. Thank you, Mr. Drance. You're excused. Thank you.
Thank
for
you.
coming forward.
Thank you.
Mr. Bayer, come into the room, and Mr. Erickson, who's on deck?
Is Andrew Beer being promoted, and Tina Wildberger on deck.
Okay. Is Tina is Representative Wildberger the last one in the room?
It's the last one with their hand up, yes.
Thank you. Mr. Baer, please activate your audio and video. There you go.
All right, apologies there.
No problem. Do you affirm that the testimony you're about to give is the truth?
Yes, I do.
So
My name is
name and address for the record, and then proceed for 2 minutes.
My name is Andrew Beer, 56 Kolola Place, Kihei, Hawaii 96753. I'm going to give my oral testimony, but also hope you'll read my written testimony as it speaks to the need for updated traffic studies and the need for DOE compliance with other luck imposed conditions, specifically conditions 1B, 1D for pedestrian shoulders, and condition 2 for annual updates. I can also address the questions that were given to Mr. Moran earlier. The Fair and Pierce traffic studies both mandate a underpass or a grade separated crossing in 2031, although I do believe they use drastically underestimated pedestrian volumes. So I think a new pedestrian study would even show greater pedestrian volumes, but they are mandated in those two studies. All right, let's talk about the intent of this condition. In 2019, the LUC reaffirmed that the intent of the condition was to provide for an over or underpass. Furthermore, at that time, the LUC reaffirmed that the DOT has no decision-making power, but only advises. Today, the intent of the condition is still true: to provide a safe grade-separated pedestrian crossing to keep students off the highway. The intent of the Department of Education should be to protect their students and provide the safest crossing to school. The intent of the Department of Transportation should be to protect pedestrians and provide a functioning highway. To excuse the DOE from this obligation does not solve or fulfill the intent of the condition. It is a disservice to the future of this community and the safety of its students. These land use commission conditions are sacred and dear to us. It is the only leverage a community has to make sure that the community gets critical infrastructure in exchange for a land use amendment. The underpass is warranted and suggested. How many years can we kick the can down the road and why? We have heard from countless experts and engineers that the underpass is feasible and recommended. And we've seen plenty of tragedy on this highway. It is inevitable. We have seen hundreds of examples of underpasses built along coastal waterways and next to raging rivers. We are in a dry gulch that barely flows, a dry gulch that is crossed every day by the hundreds of men and women working on the high school. We should be grateful that we have such a wide underpass, and experts advise a pedestrian trail is inexpensive and commonplace.
Please summarize, Mr. Bear.
The Land Use Commission has reaffirmed that the Department of Transportation has no decision-making power, but only advises. We need the DOE and the DOT to end this game of chicken. We need to move forward now. We need to move forward with good faith and immediately contact the engineers and experts to survey and design a pedestrian underpass. The clock is ticking, same as it has been for 9 years.
Thank you. Petitioner, do you have any questions for Mr. Bear?
No, Mr. Chair.
Mr. Hopper?
No, Chair.
Ms. Kato?
No questions. Thank you.
Thank you. Commissioners? Commissioner Chang? You're on mute.
Thank you, Commissioner Giovanni, and I'm going to try to keep my questions really tight. Mr. Bear, you seem like someone who's going to give me a yes or no answer. So I'm going to ask you the questions that I was asking Mr. Moran. As I understand, KCA is asking that an updated feasibility study, GPSC study, and an updated TIAR be completed. Is that correct?
Yes.
Okay. And I know you don't speak on behalf of all the community, but you seem to know a lot of what's going on. Will the community accept if the updated study says that the roundabout is sufficient, the DOT additional mitigation measures are sufficient, an underpass or an overpass is not feasible or is not required at this time? Do you believe that the community will accept that?
Not without an unbiased review. It took our review to determine that the Department of Education and their consultants were not using their own data for busing statistics. So as laymen, we have to go through these hundreds of pages of documents as if we're attorneys to make sure that they're legitimate, or are these consultants just doing the bidding of the dictators that have asked them to do this study for them?
So what's the basis? How would you determine an unbiased? Is that something that the community would participate in the selection of the expert?
Well, yeah. Well, first you read the study. And so say in this 2016 Fair and Pierce study, they estimate 20% of pedestrians would walk to school, those within 0.2 miles. Well, the DOE busing policy does not provide busing unless you live outside of 1.5 miles. So that's a 3-mile radius. That is significantly more than what was used to determine the numbers for the 2016 study.
Okay. And I guess I'm not asking for the details of what would be in there, but it's mostly a procedural question because we're faced with this very critical decision. If that underpass or overpass is not built based upon the representations, the school cannot open. So let me ask you this question. In your view, would a phased approach do the roundabout, open the school, phase 1, continue the updated studies for phase 2, and have further discussions with the community about both the updated study and the roundabout or overpass if that's necessary, and get legislative funding for phase 2 of the opening. Would that be acceptable?
I personally hold dear to a land use commission condition because once you remove a condition, your chances of ever getting it back are pretty nil. If there was a way to get the DOE to move forward with some studies and work collaboratively with our local engineers, I think you could find some solutions there. But the condition must remain until they do the due diligence and work that this condition requires.
So are you saying that the condition means building an overpass or an underpass before the school opens? That there's nothing less except that the community would not accept anything less than that?
At this point, correct.
Oh, all right. Thank you very much for your candid answers. No
You're
further
welcome.
questions.
You're welcome.
Thank you. Commissioner Wong, did you have your hand up?
Yes, Chair, thank you. Mr. Bear, sorry, I pressed the wrong button. Can't use this mouse well. My question is several questions. The first question I have is, do you, you heard me talking to Councilmember King, correct?
Correct.
So we're going through a hypothetical situation because we're not, well, I'm not living on Maui. You know, I mean, we have Commissioner Ohigashi, but the rest of us live on different islands. So do you think that the council and the executive branch of Maui will have more ideas of what should be in place in that location?
Well, that's a hypothetical question, but I think what I allude to is this has become a game of chicken where the Department of Education isn't doing any diligence and keeps bringing us back for these hearings. That brings us no closer to a solution. What we're ultimately headed towards is a school that will be ready to open without a safe crossing that was a part of a 9-year-old land use commission condition. Now, what can we do in the meantime to speed up the process? We've been speaking against this for years when they've had plenty of time. There's still time on the clock to start running some serious studies. That's what needs to happen right now before we start talking about what could happen in 2 years when the school is open and they're applying for occupancy permits. Because I agree, that it's going to be really tough to keep people out of a brand new school. But at the same time, does waiting out the community and the land use commission warrant squashing the wishes of the community and the safety of the students? It doesn't.
So no, I just was wondering if you heard the hypothetical of what if the county of Maui and the city council decides not to give a certificate of occupancy and say that it's not part of the community plan, so you cannot open up. So we say the land use, again, the hypothetical is, what if the land use commission say, right now, build the roundabout plus add stuff to the community plan?
I personally don't want to give up this condition. Like I said before, I hate to repeat myself, but once you give up a condition, you're unlikely to see him again. As commissioners, you all know that very well.
Okay. Thank you. Thank you, Chair.
Thank you, Commissioner Wong. Any other questions for this witness from the commissioners? Seeing none, Mr. Bear, thank you very much for your testimony.
Thank you for your time. Appreciate it.
Thank you. Mr. Derrickson, who's next?
Representative Wildberger, being promoted to panelist now.
Excellent.
Aloha, commissioners and vice chair. Thank you for your time and your service and attention to this incredibly important matter. I'm back with you again on this issue to oppose the DOE's request to drop this requirement.
Can I quickly have
Oh,
you?
yes, I'm sorry. Representative Tina Wildberger. I live at 2710 Kauhali Street in Kihei, and I attest to tell the truth today.
Very good. Imoa.
So thank you. For over a decade, KCA has been working to realize this vision of Kihei. It's really difficult to understand that we're here again on this issue that has already been decided twice, very judiciously and with careful consideration by this very commission in 2013 and in 2019. The community's demand for safe GSPC has not changed. South Maui residents want a walkable, bikeable community. Without safe crossing to a new center of our community, this goal is not attainable. Students crossing Pi'ilani Highway twice a day during our shift change, where thousands of drivers are commuting through Kihei to Wailea resorts, will destroy the daily commute. Like Oahu right now, commuters sit through multiple cycles at other intersections trying to traverse Kihei. That's already happening when the charter school on Lakoa gets out. The first student pedestrian traffic fatality will be on the hands of those choosing to put kids in traffic. I implore and beseech the LUC commissioners today to once again uphold the requirement for pedestrian separated crossing for Kihei High School. Mahalo.
Thank you, and thank you for your written testimony that you submitted as well.
Thank you.
So, Petitioner, do you have any questions for Representative Wildberger?
No, thank you.
Thank you. Mr. Hopper?
No, Chair.
Ms. Kato?
No, thank you.
Thank you. Commissioners, what's your pleasure? Let's start with Commissioner Okuda.
Thank you very much, Mr. Chair. Thank you, Representative Wildberger. I read I read all the testimony, believe it or not, but I read your very detailed testimony with citations to studies and other pieces of evidence. After you submitted your testimony, which appears as part of the public record on the Land Use Commission website, did anyone from the executive branch, including the Department of Education or Department of Transportation, contact you to discuss the specific studies or specific data that you included in your testimony, including the photographs that you included and the arguments you made? Did anyone from the executive branch contact you?
No, Commissioner.
Okay. Okay, Mr. Chair, thank you very much. I have no further questions.
I can see you're not accustomed to a simple yes or no answer to your questions, so that's fine. Commissioner Chang, you had questions?
Yes, I did. Thank you so much. And thank you, Representative Wildberger. I appreciate you being here again. Obviously, this is a very important issue for your community. I just have one question. And I don't follow the legislative budget process, but I was wondering, have you put in money? Have you put in requested on behalf of Kihei community any budget for an underpass or an overpass?
I have not.
Okay, thank you very much.
Thank you. Commissioners, any further questions? Commissioner Ohigashi.
On the same lines as Commissioner Chang, I seem to recall the last time we were here, or a long time ago when we talked about this, is that there was concern as to the cost of an underpass being in excess of $30 million by the DOT if it's built up to their required specifications. And I had the impression that the DOE would be seeking guidance from the legislature as to whether or not they would seek funding for that provision. Have you any idea of, one, whether or not the budget or the budgetary amounts, if there is available money in the existing appropriation for such an underpass? And number two, whether or not they have sought specific guidance from the legislature with regard to whether or not to secure such funding?
Thanks, Commissioner. I have not had any conversations with the DOT or the DOE regarding funding about the underpass. I found the Deputy Director's estimate really high because he seemed to think that he would need to raise the bridge, which would indeed cost millions.
I'm sorry, Representative Wildberger. I'm just trying to find out whether or not if you know if there is sufficient monies in the existing appropriations to pay for that type of underpass. And
Well,
because that's what the impression I got, that they will check if they have, and they would seek legislative guidance on this matter. That's what my impression was when the last time we were here. And the second part was just a question as to whether or not they sought legislative guidance, because
I don't think they have.
you know. And what about the first question? Is there any funding available? Have the legislature conducted an inquiry as to whether or not there's monies available in the existing appropriation, or whether
Well,
it's used up, pledged on?
I think for the underpass that the community is asking for, it would be very easy to allocate funding to do that. It would not be a large change order at all in the scope of that project.
I understand, but I'm asking from the point of view is there any money available in the existing appropriation that can be repurposed for that, if you know or not?
I don't have any information about reappropriating funding.
Thank you.
Thank you. That's it, Mr. Commissioner. That's the end of it. Okay. Any other questions from commissioners for Representative Wildberger?
Chair.
Yes, Mr. Wong, Commissioner Wong, please proceed.
Thank you, Chair. Good afternoon, Representative. I got a question. This is legislatively dealing with this issue. Could the legislature do I guess, an info brief or something with the DOE to bring it up to the legislative level? To, you know what I'm saying? You know how there's always info briefs or something, and say, hey, DOE, come and inform us of what's happening, what you need, and why you're not doing it. So could the ledge do something like that?
Typically, the info briefings are held and conducted by the chairs of those committees. Representative Justin Woodson is the chair of the Education Committee, and that is something that he certainly could do on our behalf.
Yeah, it's just that, there is, as we say, there's phase 1, phase 2, phase 3, I believe, for the Kihei High School. And I think at one of our hearings, we say, there's appropriated money already in phase 2 or phase 3, reappropriate it for this issue and put it part of the info brief, and then talk to Chair Luke and say, hey, we want to do this. Can we do this? Something like that.
Thank you. It's an excellent suggestion.
Yeah, that's all. Thank you, Representative. Thank you, Chair.
Thank you, Commissioner Wong. Okay, one more time. Any follow-up questions from any commissioners from Representative Wildberger? Seeing none, thank you, Representative, for being with us today and for your testimony.
Thank you all for your time and careful consideration. We appreciate it so much.
Thank you. Mr. Derrickson, anybody left with their hands up?
There's no one else in the audience with the hands up?
Okay, this will be the last chance for anybody to raise their hand. I'm going to give it 5 seconds. If not, we'll close public testimony. So counting down in my head. Anybody raise their hand?
No.
Okay, so we will close public testimony for this docket. But I again want to reaffirm the Commission's appreciation for the written testimony and the volume of that testimony that came in on this docket. We take that very seriously, so thank you. So we'll now move to the petitioner's presentation. Mr. Fujioka, recognizing we've got about 17 minutes on the clock before the targeted deadline. Do you have, what is your pleasure? How would you like to proceed?
I had wanted to share that one of our exhibits, that PowerPoint presentation, but I'm having difficulty sharing screens. So I'm wondering if I should get that resolved and then perhaps resume tomorrow with our presentation, since it's like 2:45 already.
2:45. So are you basically saying that you've got nothing meaningful to present in the time available to you at this time?
I mean, I wanted to present through the PowerPoint, and I don't know if my screen will share. I can try checking because I could. Is my screen up on now?
Yeah, and we see a
Is-
PowerPoint.
Says Kihei High School LUC docket.
Yeah.
O-
So how long
Okay.
did it take you to go through this PowerPoint?
I hope less than 15 minutes.
Okay, proceed.
Okay, just since it's been a while, since that we were here to address this issue, I wanted to go through a little bit of the history of what has happened from the petitioner's point of view. So I think everybody knows that we're trying to have the grade separated pedestrian crossing requirement removed from the boundary amendment so that the school can open for the 22-23 school year. Some things that have happened since the filing, or this most current filing, is now we have a principal. Her name's Hallie Maxwell. She used to be, till August 1st, she was the principal of Kihei Elementary School. She's invested in the community. She's been living here, I think, at least 20 years. And there's going to be a later slide that shows that confirms that she's committed to meeting once a month with the community. She's already started. So, I think that's very encouraging in terms of trying to get the school up and running on schedule. I know some have been critical of the traffic and pedestrian studies that have been done, but there have been a number of them. Back in 2011 and 2012, there was the traffic impact report, including a traffic signal warrant study. We recently submitted this as Exhibit 38 in one of the supplements. This was one of the earlier ones, or actually, I think it's the earliest, was done for Wilson Okamoto, or by Wilson Okamoto, the original engineers. Then there was a Kihei High School pedestrian and bicycle analysis. That's the Stantec report. We submitted that one a while ago as Exhibit 26. That one was from 2012. So these two studies actually preceded the findings of fact and conclusions of law and order, which were filed July 29, 2013, and the DOE is seeking to have amended currently. Then in 2014, Walkable and Livable Communities issued this Safe Routes to Kihei High School, that pedestrian route study from 2014. Initially, it was submitted as Exhibit 2, and then when Commissioner Okuda made his request for additional reports, this was one of them. So now it's all in its entirety, it's included as Exhibit 42. And that at that point, the Department of Transportation had not approved the pedestrian route study. So additional work was done, and this Fair and Peers report of October 25, 2016, which is Exhibit 4, that was done in 2016. Subsequently, in 2017, that's July 18, that's when the DOT approved the traffic study. And one of the important conclusions there was that the grade separated crossing warrants were not met. That Department of Transportation letter is Exhibit 5. And then Subsequently, notwithstanding that, the commission issued its declaratory order April 25th, 2019, reaffirming the grade separated pedestrian crossing requirement. Subsequently, Fair and Peers did a study August 1, 2019, and that's in as Exhibit 11. And that one, I believe, concluded that the grade separated crossing was not warranted. And after that, there's been some additional work. July 28, 2020, WSP did a roundabout evaluation. That's Exhibit 8. So there's been quite a bit of work done on the necessity of grade separated crossings and the desirability of a roundabout. So it came a point where the roundabout became the most viable solution recommended by the Department of Transportation. And even if the motion is granted, the preceding condition still requires further updates for traffic studies. The DOE would still be required to do several more traffic impact analysis reports. First one to be 1 year after opening phase 1 of the project, which would be the school. There's been some confusion because there's phases in Roman numeral and there are construction phases in Arabic numerals. But I think phase Roman numeral 1 is the opening of the school. So 1 year after that, there's going to be a TIAR. Then there's another one before phase 2 can be occupied. And another one after phase 2 is, or 1 year after phase 2 is built out. And meanwhile, if there's any delay over 3 years, the TIR needs to be updated again. So it's going to be an ongoing process to carefully monitor whether the safety measures are adequate. So these are some of the things procedurally that we've done. August 20, the current motion was filed. There were 2 hearings, September 10 and November 4. And granted, at the strong urging of the commission, there was a meeting with Kihei Community Association, October 27. There was, then after the October 4th hearing, DOE received a request dated November 10 for additional information. So that was submitted February 1. And in the meantime, January 12, there was a virtual meeting with the DOE, Department of Transportation, and the community. 1 week later, DOE added some web links and photos to its website. And okay, so after that February 1 response, construction updates were uploaded to the website. And then there was another DOE virtual meeting, August 17, 2021. That's the one where the principal, Hallie Maxwell, was also involved, as was the complex area superintendent, Kathy Dimino. So this is what phase 2 is anticipated to be. This is something that was obtained from, I'm on page 7 of this PowerPoint. The DOE's Assessment and Accountability Branch of the Office of Strategy, Innovation, and Performance was consulted. And as of May 5th, 2021, which is towards the end of this school year, they look at all of the demographics, who's living in the area, who's going to middle school, where, and so forth. And what they came up with is for the target opening year, 22-23 school year, they're only expecting 167 ninth graders to enroll in Kihei High School. A decision was made to start with ninth grade only. So we're looking at 167 ninth graders for the first year. Then the second year, they're going to bump up to 299, adding 10th graders. But in the fall of 2023, there's going to be that 1 year where another study has to be done. And then there will be further studies if we get to the point of phase 2. And the other thing that that's contained here is a slideshow that was shared with the community on January 12th of this year. This is the Department of Transportation's presentation. So I'm hoping that a little further on, I can get some assistance from a representative of DOT to clarify the slides here. So I'll stop sharing this. And so that I just wanted to provide by way of update because some of that stuff was reviewed and a few things have happened since. So
just a quick question.
Yes.
To clarify, that last part of your shared screen showed a different PowerPoint. I think you said it was DOT's PowerPoint. Is that an exhibit on the record in this petition, in this matter?
It's part of that same exhibit 45, but it's something that I would want to review with the DOT representative.
Understood, but it's in the record is what my
Yes.
question.
Yes, it is. Thank
Okay,
you.
thank you. Continue.
And so we respect the input of the community, and it's hard to be in this kind of disagreement, but all of the studies that have been available have shown that the roundabout would provide safe pedestrian crossing and auto vehicular traffic. And there's knowing that we're going to start, or they're projected to start with a lot fewer students than originally anticipated. I think if the motion is granted, starting with a roundabout, which is already being, if it's not being constructed, the foundation is being laid for it. And the school is ready to get up and running. I think it's time to just address this grade separated pedestrian crossing in light of the availability of a roundabout, which wasn't considered before. And the studies that have told us that the underpass especially is not warranted and it cannot be done safely. So those are the things that are the reasons we want to go ahead and proceed with the school using a roundabout, safeguarding the initial 167 students, and mindful that additional studies will need to be done. Thank you.
Commissioner Cabral, did you have a question?
Yes, and I know time is of the essence, but since the initial introduction, and this is to Mr. Fujioka, I'm not really I want to have a better understanding who you work for. Are you employed by the government? What agency, state? Are you an attorney with Department of Education? I mean, exactly where do you fit in the large picture here.
I am a deputy in the Department of the Attorney General. I work in the Education Division. So one of the main things we do is represent the Department of Education in education-related matters.
Okay, thank you. And then my second question is then, can you identify for me, hopefully it's simple, it surely is in business, who is the decision maker in this case?
For the DOE?
DOE, oh, I'm sorry. I was
For this
looking for a person. I mean, is this just the proverbial, the government made this decision? I'm just concerned, who, I mean, there's got to be a person or a title. Is there a title? I mean, is DOE seems like an awfully big title to making a decision. I'm just kind of curious as to, is it the, I mean, I don't know. I'm looking for who makes these decisions?
You mean the decision to request removal of the grade separated crossing?
Well, that would be a current decision. And then a few years back, the decision to somewhat ignore what the LUC said, et cetera. I mean, is there a title of who makes these decisions?
I was not involved at the time, and I don't know who actually made the decision, whatever that decision was to, I don't think it was totally ignoring what the order was, but in terms of traffic control and roadways and crossings and so forth, the DOE does have to defer to the Department of Transportation.
So it's just sort of the government in general, various, and then the legislature funds or doesn't fund, you ask. I've got a concern here. I mean, thank you to the government. I've been to several seminars in my time at the land use, and I've got to tell you, the entire direction that communities and urban life and people are looking at is, instead of sprawling out all over the land, is consolidating so that people can walk to school, that they can walk to work, that they can bicycle places. And so meanwhile, 8-9 years ago, LUC said, yeah, this is a lot of land based on allowing people to walk and to bicycle to school. And if I knew then, if I was on the LUC then, and I knew that this requirement was going to be decided against or ignored, as the case may have been, I would have said, make it a 10-story building somewhere in the middle of where the community is, if necessary, if all you've got is 5 acres or something, instead of a massive, and have an elevator and have kids be able to get there safely, because that part of these decisions is trying to build a community in addition to having children be safe. I mean, I'm concerned as to who makes the decision, and at what point, when the body count gets at some point, do you look at those decisions again? So anyway, Mr. Fujioka, if you're all able to find out what title of what person makes those kind of decisions, I'd truly appreciate it. Thank you.
Thank you.
Commissioner. So Mr. Fujioka, I'm going to move to adjournment here shortly, and we'll resume tomorrow with your presentation and Q&A on your presentation of your case. Let me encourage you to have representatives from DOE and DOT in attendance if you can. That would be helpful. Let me also say that in terms of the agenda for tomorrow, we're obligated to take up the Maui solar matter first. So we would resume on this docket following the completion of that agenda item. Does everybody understand that?
So it would be kind of like today.
Kind of like today. I can't predict how long the Maui solar docket will, I think it's an Oahu solar project will take, but it'll be first. Okay?
Okay, thank you.
Understood. And so with that, do I have a motion for adjournment for today? Or do I need a motion? Kathy, I don't need an motion, so I'm going to adjourn the meeting for today. Thank you very much. And we'll see you, I will see the fellow commissioners and participants at 9 o'clock tomorrow. Thank you.
Good job.